We're on.
All right,
Thank
very
you, Chairman
good.
Campbell.
I want to welcome everyone to the April 4th meeting of the Board of Architects and Engineering Examiners. We are in Davy Crockett Tower, Conference Room 1A. This meeting was noticed on our website. And let's see, that's probably about it. So if I can have a roll call.
Susan Ballard.
Here.
Robert Campbell.
Present.
Ricky Bersai. Grant Minshew.
Here.
Blair Parker.
Here.
Brian Tibbs.
Here.
Rick Thompson. Frank Wagster.
Here.
Kathy Ware.
Here.
Alton Heathcote.
Tickled absolutely to pieces to be here.
Stephen King.
Here.
You have a quorum.
Thank you very much. So we've got some guests in the audience. I see. Did everybody sign in? All right, very good. I see some old faces and some familiar faces. We'll let you introduce yourself whenever it's time for you to get up if you need to do that. Any announcements from Roxanne or anybody else?
The only thing that I did want to announce is, as Ashley and I just spoke, because we do have one board member participating electronically, any of the votes will have to be by roll call. So we'll try to not delay those and go through those that are appearing before us and include Susan in on the votes. Thank you.
Very good, thank you. Anybody, after looking at the agenda, any changes that you'd like to make? All right, very good. Well, we'll consider the agenda set as printed. And on page 3 of your iPads, you'll see the minutes for our February meeting. Give you just a chance to kind of refamiliarize yourself. I'm sure most of you have gone over them. Anyone who would like to make a motion to approve those?
Mr. Chairman, I have a correction. Okay. On page 10, under Director's Report, it says motion was made by Ms. Ward. So if you can change that to Ms. Ware, I think that was me. And then I just wanted to ask if I specifically asked something last board meeting as to record in the meeting minutes that, again, I'd like to press for us to be able to have a newsletter or some regular communication with registrants. And I specifically asked that that be recorded into the minutes. I'm not sure that I see it. Roxanne, if it's in there and you point me to it, that's great.
I'll review it if I do find it. I know we made it a point to not miss it, so I'll make sure that if it is, I can point it to you. If not, we will add it and make the correction on page 10 as well.
Anything else? Okay. All right. So if I can have a motion to have the meeting minutes approved with the changes noted.
Motion.
Have a second. Second. Okay. Now we got to have a roll call, correct?
Correct.
All right.
Susan Ballard.
Aye.
Robert Campbell.
Yes.
Ricky Bersai. Grant Minshew.
Aye.
Blair Parker.
Aye. Yes.
Brian Tibbs.
Aye.
Rick Thompson. Frank Wagster.
Yes.
Kathy Ware.
Yes.
Passes.
All right. Thank you very much. I would say do we have professional society reports, but we probably have a professional society report if you're well. Good deal. Casey just texted me she's going to be running a little bit late if she's able to make it. So.
Good morning, Mr. Chairman. I'm Nathan Ridley. I did not get the short straw today. It's a busy day in the legislature today, and I suspect that's where my colleagues are. I'm here on behalf of the Tennessee chapter of the American Society of Landscape Architects, and the legislative session is winding down. They'll probably be done about the middle of May, which is probably a good thing. Some hope for early May, but I tend to be pessimistic on finishing just because they always have something that bubbles up that takes up time they might not expect. I guess y'all have a couple of bills in your packet that y'all might talk about later, and I would encourage you to review those. One affects particularly, there's one entitled A Right Turn, a Living Act, that has an impact on the design professional communities that folks have some level of concern with. Just as a lawyer, I kind of like it because it probably gins up some legal work. But from a regulatory perspective, I think y'all should take a close look at that one because I think it brings the prospects of some litigation that you're probably not used to having right now, where the board would have to defend actions, and probably not in the city of Nashville. It could be in Grundy County or any county. The venue for the actions would lie where the petitioner lives. And then last but not least, the landscape architects are having their annual conference in Memphis on the last weekend of this month. We're excited. We're going to have Carol Coletta, Memphis, on behalf of the Memphis River Parks Partnership, is going to be the keynote address on Thursday night, the 25th. And speaking of that weekend, not that I'm leaving town on purpose, but if you're coming to Nashville that weekend, you should already have a hotel reservation, because if you've been living in a cave, the National Football League's going to be in town for their draft. And apparently, I'm a big college football fan, but it's a big draw it's going to be a huge event for the city. And then that Saturday, we have our marathon. That's a big draw for our city, and there's going to be some overlap there. So Gallatin's not that bad a place to stay where I grew up, but just food for thought there. But anyway, back to the conference. We're tickled to death that we have an annual conference once a year, and we rotate around the state. We're excited about going to Memphis. It's going to be in a new venue for us, the Halloran Center, right downtown. So that's going to be a good event. We're tickled about that. And that's all I have. Happy to respond to your questions or comments or observations.
Good. Any questions, comments from anybody?
May I also add, for the landscape architects, we do have the Day on the Hill next week.
Yes.
Here in Nashville.
Sorry, last but not least, yes, on Wednesday we'll do our breakfast and biscuits and brochures for our legislative friends. Thanks, Blair. Apologize. Yes, okay.
Nathan, have you heard whether or not there's still any movement that the AE board or other professions might be exempted from that particular legislation? The accountants apparently have.
That's a good question. Kind of the art of the legislative science is sometimes for bad bills, you just like to beat them. But if you don't have the votes to do that, you might want to exclude certain professional groups. And the accountants have had some success with that. And we've talked to the architects and engineers and the landscape architects and interior designers. We've all talked about the possibility of that for this board, just because I think we can justify it sort of the way the accountants did. It's a professional degree, and there's a code of ethics for it, and it's all. So that, yes, that is an option that we're talking about. Thanks. And thank y'all very much.
Thank you, Nathan. Yes. All right. Thank you. So we'll go to the legal case report, please. And I believe that starts, and I'm sorry I got off my...
Page 32.
Yep. Off my main page here. Searching 34.
I apologize.
Yeah.
Good morning, board members. The first item on our legal report today is complaint number 2019-005571. Here, the respondent entered into a stipulation and final agency order with another state's board for failing to report a disciplinary action in another jurisdiction within the required time period. The respondent was initially disciplined After entering into the jurisdiction to meet with a potential client for the purpose of providing engineering design services prior to obtaining a license to practice engineering in that jurisdiction, the respondent indicates that upon reviewing the applicable jurisdiction statute and determining he was in violation, he self-reported to that initial jurisdiction. The mitigating factor here is that there was a previous complaint opened against this respondent for the discipline in the initial jurisdiction, which was already closed with a letter of warning or a letter of caution. So we are recommending closing this complaint. Thank you, Roseanne.
Questions, comments?
Curious, how did Tennessee find out about this, hear of this? Did I miss something here? The respondent did not self-report this to the board, so how did we find out?
The administration found out about it, or the board office.
We go ahead and update our records of anybody that has discipline, and when we're in NCEES, if we see any Tennessee architects or engineers, so forth, we would then be able to see. And
You cross-check. Whenever there's
Cross-check.
information available, you cross-check
Correct.
it against our...
correct what's in our
Yes.
national organizations. Yes.
Yeah.
Mr. Chairman, I move we agree with our legal recommendation and close this case.
Good. I have a second on
Second.
that. Any discussion? All right, so let's have a roll call.
Susan Ballard,
Aye.
Robert Campbell,
Yes.
Ricky Grant Minshew,
Yes.
Blair Parker,
Yes.
Brian Tibbs,
Yes.
Rick Thompson, Frank Wagster,
Yes.
and Kathy Ware.
Aye.
Passes.
The next item on the legal report is complaint number 2019005-631. This respondent's registration expired on March 31st, 2018, and in his expired license affidavit, he did note that he practiced engineering on his expired license. By letter, he explained that during the expiration period, he completed and sealed one project. He further advised that he understands it's his responsibility to be aware of renewal dates and that he failed to realize his license expired until recently. Mitigating factors were that he did self-report this. Legal is recommending authorization for a formal hearing and authorization of a civil penalty in the amount of $500 for practicing on an expired license. Respondent is also to take and pass the laws and rules examination.
Why do we need a formal hearing if you're already recommended all this stuff?
The civil penalty and laws and rules examination would be part of a settlement offer, and if the respondent does not accept the settlement offer, which they're not required to do, then in order to proceed forward, we would need authorization to have a formal hearing to come before you all and present the facts of the case.
We state that just slightly different. And I go again, you did much better on this than I did as far as the English language, but can we have those who maybe in the future says authorize a formal hearing if the applicant doesn't accept? Because it looks like we're doing that in addition to just when we look at it.
Sounds like you're penalizing him and you're going to have a hearing.
That's actually how I read it when I first went through these.
That's why I ask.
So, I mean, if you can, I understand why we need to authorize a formal hearing, but if we can say authorize a formal hearing if respondent does not accept the civil penalty and the consent order that we're presenting. Right. I mean, it just makes it a little clearer for us because it does look like you're asking for all three things in one piece instead of we're going to do this, and if he doesn't do that, then we're going to be able to do this. And
Yeah, sure. We can definitely do that moving forward.
One additional item, because there are several coming next that are of similar flavor, I suppose. The $500 penalty, that's consistent with what we have done in the past, and it's hard for me to go back and look and to sort of verify that. But is that $500 consistent with what we've done in the past?
Yes, it is.
Thank you.
All right, any more discussion? Do I have a motion?
So move.
Second? All right, roll call.
Susan Ballard,
Yes.
Robert Campbell,
Yes.
Grant Minshew,
Yes.
Blair Parker,
Yes.
Brian Tibbs,
Yes.
Frank Waxter,
Yes.
and Kathy Ware.
Thank you. Item number 3, please.
Our next item is complaint number 2019-005641. This is another practicing on an expired license. This person explained that during the expiration period, he stamped drawings for one warehouse interior renovation. He also explained that he inadvertently missed the registration deadline due to the process being new to him. He explained his old firm took care of registration renewals. Mitigating factors is that this was self-reported. Legal would recommend, again, authorization for a formal hearing and then authorization for a civil penalty in the amount of $500, as well as requiring the respondent to take and pass the laws and rules examination.
All right. Any discussion? Do we have a motion? Yeah.
But I make a motion to approve staff recommendation.
Second. Any more discussion on the motion? All right. All those in favor say aye. Oh, excuse me. All those roll calling say aye.
All those.
All those in favor of a roll call say aye.
Susan Ballard,
Aye.
Robert Campbell,
Aye.
Grant Minshew,
Aye.
Blair Parker,
Aye.
Brian Tibbs,
Aye.
Frank Waxter,
Yes.
and Kathy Ware.
Aye.
Passes.
All right, thank you. Item number 4, please.
This is complaint number 2019-005661. This is another expired license issue. This person noted that they did practice architecture on their expired license and explained that during the examination period, he sealed approximately 3 projects with his stamp. Again, this was self-reported, and legal would again recommend authorization for a formal hearing and authorization for settlement in the amount of the settlement for a civil penalty in the amount of $500 for practicing on an expired license, and then also respondent is to take and pass the laws and rules examination.
Does it matter about the last 2 just for a few months when they, March 30? Like he was over a year. Do we still consistently keep with the $500 no matter the time period? Generally speaking, I'm okay with it, but I just wondered if the time period matters at all. Or maybe I should say historically. That's probably a better way to say it. Historically, is there a time period issue? And I know you're new to it, but
From my understanding, historically, y'all do the $500 civil penalty and then the laws and rules examination for people who are cited for practicing on the expired license. Yeah, regardless.
no one else has any discussion about it. I'll make a motion that we accept staff's recommendation.
All right, is there any discussion? And a good question, Brian. I think just quickly, I think we tend to also look to see if it was something that maybe was intentional, if there is some way to determine that, and if they had a huge amount of work and 3 projects is maybe not as big a number, especially since they self-reported and came in. Any other questions? All right. Wanda, let's have a roll call, please.
Susan Ballard,
Yes.
Robert Campbell,
Aye.
Grant Minshew,
Aye.
Blair Parker,
Aye.
Brian Tibbs,
Aye.
Frank Waxter,
Yes.
Kathy Ware.
Aye.
Pass.
All right, thank you. So I got it?
Pass.
Who's passed? Me? Who? Pass.
Motion passed.
Oh, I'm sorry. I was sitting there going, who passed? I didn't hear anybody pass.
Oh,
I got confused. I'm sorry. I thought maybe Kathy was bowed up and was going to pass on it or something. I thought she said aye, but maybe I didn't hear right. Very good. Thank you. Number 5, please.
This is complaint number 2019007-061. Again, this is a respondent practicing on an expired license. This person explained that during the expiration period, he performed work on 4 projects. He also explained that he deeply regretted allowing his license to expire and to providing engineering services during his lapse. He stated he was unaware of the lapse, and upon discovering the error, he immediately submitted a request for reinstatement and completed the reapplication forms on the website. Again, mitigating factor self-report here. And as with the others, legal recommends authorization for a formal hearing and then authorization of the civil penalty in the amount of $500 for practicing on an expired license. And the respondent is also to take and pass the laws and rules examination.
So move.
Second.
Second.
Any discussion? All right. Let's have a roll call, please.
Susan Ballard,
Aye.
Robert Campbell,
Aye.
Grant Minshew,
Aye.
Blair Parker,
Aye.
Brian Tibbs,
Aye.
Frank Wagster,
Yes.
Kathy Ware.
Aye.
The motion passes.
Thank you. Item number 6, I believe.
This is complaint number 2019005-041. This respondent was disciplined via civil penalty by another state's board for failing to notify that board of a license discipline in another jurisdiction, which stemmed from a license discipline in an initial jurisdiction in 2009-2010. The basis for the discipline in the initial jurisdiction was the performance of engineering work under a corporation's name, while that corporation did not have a certificate of authorization in the initial jurisdiction. In response to this complaint at issue, the respondent indicated an understanding of this board's concern upon learning of the discipline and asked the board accept an apology and pledges the past mistakes will not be repeated. A mitigating factor here would be that a complaint was previously opened against this respondent for the discipline in the initial jurisdiction, which was closed with a letter in 2010. So legal's recommendation here would be to close.
So move.
Second.
Any discussion? All in favor say aye.
Susan,
I'm sorry, roll call. I'll get
Susan Ballard,
Aye.
Robert Campbell,
aye.
Grant Minshew,
Aye.
Blair Parker,
Aye.
Brian Tibbs, Frank Wagster,
Yes.
Kathy Ware.
Aye.
The motion passes.
You didn't let me finish my sentence. I said all in favor say aye on the roll call. That's what I meant to say. I was getting there. I just had to take a breath, so it didn't get there like I wanted to. Item number 7, please.
All right, this is complaint number 201900861. This respondent self-reported disciplinary action and civil penalty by another state's board for practicing on an expired license. The respondent reported his license is now current with that state's board. The respondent also reported that he has not practiced in Tennessee with an expired license and he has no current projects in Tennessee. A mitigating factor here is that he did self-report. Legal would recommend a letter of caution.
So move.
Second. Any discussion? All right, roll call, please.
Susan Ballard,
Aye.
Robert Campbell,
Aye.
Grant Minshew,
Aye.
Blair Parker,
Aye.
Brian Tibbs,
Aye.
Frank Wagster,
Yes.
Kathy Ware.
Aye.
Motion passes.
Thank you. Next item, please.
The next item is complaint number 20190109191. This is another expired license issue. In an expired license affidavit, the respondent noted that he did practice engineering on his expired license. By letter, he explained that during the expiration period, he performed work on 13 projects. The respondent indicated that he believed he had renewed his license online, but it was not until a fellow engineer informed him that his license had expired that he realized he was operating without it. The respondent also indicated that during that time, they had a water line break at his office and the ceiling directly above his desk, which destroyed about 15 to 20 ongoing job folders, his continuing education certificates, and damaged many more files and original drawings. The respondent states that he has not practiced engineering since he found out his license expired. Mitigating factor here is that he did self-report. Legal would recommend authorization for a formal hearing, authorization for a civil penalty in the amount of $500 for practicing on an expired license. The respondent is also to take and pass the laws and rules examination.
Motion to approve staff recommendation.
Second. Any discussion? All right, let's have a roll call, please.
Ballard,
Aye.
Robert Campbell,
Aye.
Grant Minshew,
Aye.
Blair Parker, Brian Tibbs,
Aye.
Frank Wexler,
Yes.
Kathy Ware.
Aye.
The motion passes.
Item 9, please.
This is complaint number 20190099731. Here, this is a consumer complaint. The complainant alleged her ex-husband works for the respondent and may be engaging in the unlicensed practice of architecture. In support of her allegation, she provided part of a floor plan which was listed as drawings provided by ex-husband. These plans appear to fall within the exemption listed in Tennessee Code Annotated 622102. This case was sent to Rick Thompson for review, who recommended the case be closed. So legal's recommendation here would be to close the complaint.
So move.
So moved. Do I have a second? Second. Any discussion? Roll call, please.
Susan Ballard,
Aye.
Robert Campbell,
Aye.
Grant Minshew,
Aye.
Blair Parker,
Aye.
Brian Tibbs,
Aye.
Frank Wexler,
Yes.
Kathy Ware.
Aye.
Motion passes.
Thank you. Item number 10.
This is complaint number 20190154141. This is another expired registration issue. In her expired license affidavit, the respondent noted she did practice architecture on her expired license. She explained that she was unaware her license had expired and that she immediately stopped work upon realization of expiration and started the reapplication process. During the lapse period, she submitted permit documents for a small 1,250 square foot interior office in one city and submitted permit documents for a multifamily development located in another city. Mitigating factors is that this was self-reported. Legal would recommend authorization for a formal hearing and authorization for a civil penalty in the amount of $500 for practicing on an expired license. Respondent is also to take and pass the laws and rules examination.
So moved.
So moved. Do I have a second?
Second.
Any discussion?
Yeah, I have one question.
Yes.
Is this any different than the others with regard to the fact that she became aware of the fact that she was not currently licensed and she continued to practice by submitting permits for a multi-family development? To me, that is slightly different than someone who, the ones we discussed. Go ahead.
From my understanding, she stopped work when she realized her license was expired, and that was done before she realized her license was expired. So it was done. That work was done during the lapse period, but before she became aware that her license was expired.
Gotcha. Okay. I follow. That's why I was asking. Thank you.
Good question. So we've had a motion and a second, I believe. Okay. Good deal. So any more discussion?
All of these, the board has approved the recommendation for legal. They all go back to the same, I guess, caveat that appeared in number 2, correct? That the two be separated, authorized formal hearing be separated from, okay.
If they don't accept, yeah.
I think that just helps us know that we're not, I mean, we're doing that in the event that the other item does not get resolved. Yes, sir. That's good clarification. All right, so let's have a roll call, please.
Susan Ballard,
Aye.
Robert Campbell,
Aye.
Grant Minshew,
Aye.
Blair Parker,
Aye.
Brian Tibbs,
Aye.
Frank Waxter,
Yes.
Kathy Ware.
Aye.
Motion passes.
All right, item number 11.
This is complaint number 2019-01-5151. The respondent's registration expired in their expired license affidavit. They noted that they did practice engineering on the expired license. By letter, they explained that they did not stamp any plans during the expiration period, but did work as an engineer in their current job capacity. The respondent also explained that the lapse was due to his misunderstanding regarding the difference between the annual tax and the board's license fee. He asks the board for forgiveness and states that he appreciates the time to review his application for renewal. Mitigating factor here is self-report. Legal would recommend authorization for a formal hearing, authorization of a civil penalty in the amount of $500 for practicing on an expired license. Respondent is also to take and pass the laws and rules examination.
Second.
I'm going to make just one quick comment, and I think it's something we'll talk about it as we look at I think it's the meeting minutes from the engineering committee. Steve, is that right? Where I got that document? Last month's meeting. So I think we had an opinion that if a licensee did work that was exempt, and they use. Tell me again, because I'm getting my facts messed up here, and I'm gonna get to a point.
There's a memo in last month's agenda from legal that where there was a question at a previous board meeting about whether or not a registrant had to stamp work that was done that our law didn't require him to do, and the board in the past had used something in the rules to say that reports or things would need to be stamped, and the opinion was that if our law didn't specifically require that work be stamped, that it didn't have to be. That's my summary, but maybe Ashley has a better.
Well, my only
summary.
point on this one is this person actually didn't stamp anything during this 2-year period. But they were an engineer. So again, using the same kind of logic that opinion had, then we shouldn't really do anything because they were just an engineer during that time. And I mean, I think we need to discuss that opinion a little bit more, and I think we need to do it in an engineering committee meeting, not here, because our opinion, I think, as board members is, and I'm sure it's the same thing for an architect. If somebody is an architect and they hold themselves out to be that, it doesn't matter if something is exempt. If you're saying if you're going to put that architect designation after your name, there's an expectation from whom you're doing work for that they're getting an architectural service, whether it's maybe an exempt thing or not. And same thing from an engineer. I think there's an expectation from the public that when we put Robert Campbell PE, that's an engineering thing, and they're getting an engineering service regardless of exemption or not. So I just think, Ashley, we probably ought to talk about that a little bit. I don't necessarily 100% disagree with what you've said, but it's not really as consistent with that opinion. I think when we hold ourselves out to be engineers or architects, whether it's exempt or not, the public has an expectation that they're hiring us for that expertise or that higher level of commitment to something. So anyway, if we can put that on the engineering committee for next month, and I kind of passed over it, didn't bring it up sooner, so that's my fault. Okay.
Yeah, I was going to ask about the whole issue with regard to, he says he functioned as an engineer in his job capacity, but explicitly did he say he did not seal anything? That was a question I had.
He stated that he did not stamp any plans. during the expiration period.
Well, then I mean, I do think that's different than the other people who submitted permit documents and said that they issued project drawings with seals on them, et cetera. We have a lot of engineers that are in business and they're more managers now than they are necessarily designers or licensees that stamp drawings. And I do think that is different than the previous cases. And I would be more in favor of a letter of caution that he understand that he could have put himself in peril, but because of the fact that he did not represent to a client that he was delivering a work product as a registrant, that he not be subject to the $500 fine. And I realize we've already have a motion, but that's my discussion part of it.
Right.
I see that a little bit differently. Maybe he didn't seal something, but I guess that you could carry it a little further is are you putting yourself up as being an engineer, a professional engineer? Is it in the advertising in his company? Are the clients he's working for expecting him to be a licensed engineer? Whether or not he seals the drawings, there's a lot of big companies that only the partners in the company seal the drawings. I'm not sure I agree with that, but I mean, it's in their responsible charge. But if he's working and designing as a professional engineer, whether or not he seals it, I think there's a reason there to do exactly what's being represented here. I mean, recommended by the legal. So,
And I agree that might be the case. And if he was representing himself as a person of authority who was offering even verbal engineering judgments and whatnot, then I think I would find that a compelling argument. I just don't know. Do you know?
In his affidavit regarding expired license, he did check off and testify that he practiced engineering in the state of Tennessee since his certificate of registration expired.
Okay. All right. Well, I'm good with that. I just didn't want someone to be on the hook just because they had a job somewhere. That was kind of the way I read your explanation, engineer in his job capacity or whatever. But if he admits that, then that's good enough for me. Yeah.
Good discussion on that, because I think that's whether we stamp or we don't, we still hold ourselves out to be that, and the public has that expectation. So very good. All right. So do we get a motion on that, or do we just? Okay. Okay. I get confused. So it's time for a roll call.
That was number 11. Yes, there was
Yes.
a motion
Yeah.
and a second.
All right. Very good.
Susan Ballard,
Aye.
Robert Campbell,
Aye.
Grant Minshew.
Aye.
Blair Parker.
Aye.
Brian Tibbs.
Aye.
Frank Wagster.
yes.
Kathy Ware.
Aye.
Motion passes.
Item number 12.
This is complaint number 2019-008-541. This was a competitor complaint alleging the respondent signed and sealed across numerous trades as engineer of record. The complainant alleges that he finds it difficult to believe that one individual can possess the knowledge and capacity to provide expertise in so many fields. However, the complainant did not specify any specific areas of concern with the respondent's work product. In response to the complaint, the respondent addressed the allegations and explained his qualifications. Based on the nature of this case, the complaint and response were sent to Steve King for review. Mr. King found no practice outside the respondent's area of expertise, so legal would recommend close.
Comments? Good.
Yeah, I'm good unless you want me to say something.
Any motions?
So moved.
Second. Any discussion? All those in favor, go to the roll call, please.
Susan Ballard,
Smooth.
Aye.
Robert Campbell,
Aye.
Grant Minshew.
Aye.
Blair Parker.
Aye.
Brian Tibbs.
Aye.
Frank Wagster.
Aye.
Kathy Ware.
Aye.
Motion passes.
Like we've got a lot of forgetful souls this period, so hopefully that doesn't keep going. Yeah, do we still send a reminder of licensure expirations, don't we?
We do.
That's what I
The
thought.
statute requires we mail them. And for the most part, they don't come back. They get there, but yeah.
I thought I had seen mine too as well, so just want to make sure. Okay, very good. All right. Next item is legislative updates. Okay, well, but yeah, before we do that, let me go ahead and squeeze in our professional societies and have them. Actually, if you want to come up here, Nathan threw y'all under the bus, but it was gentle. I don't think you're going to see many tread marks from it, but you might experience some soreness.
Right. Okay. I don't have a lot to report. I wanted to let you know that AIA did release a press release yesterday on a study. Oh, I guess my name's Ashley Cates. I'm Executive Vice President of AIA Tennessee. AIA National released a study on QBS procurement yesterday. So I will send that out to y'all. The results were good and in support of QBS procurement and the satisfaction rate from the end users. So I will send that to you all. That's good news just for us in general. Also, I wanted to see a thank you for posting the QBS manual, that the guide for procurement for procuring professional design services is up on your website now. So I want to thank you for that because I've already had to send it out to some governments. In that note, I was going to see if there was a way, there's multiple redline versions listed, I think just from where I had our revisions. So I was just going to see if those could be taken down to, stop any confusion or anything like that. So that's great because I do appreciate that. That's useful for me. In addition to that, we're just trucking along with legislative session. The architects in general, working with the coalition, I believe I reported this in February, regarding historic state credit taxes. And so, sorry, I'm just a little off base today. So we have been meeting with administration. We've been meeting with legislators. We have support. It's just really trying to find the funding to get the program off the ground. And so we're looking at different ways to do this through enabling legislation and then moving forward. So we think it's a really good thing for the state of Tennessee to save our historic buildings and to be able to keep those buildings for the future generations and create economic development and some tourism aspects of it. So if you all would like more information about that, I have plenty of it. Other than that, our conference is coming up in July in Knoxville. We're excited about it. We're also looking at a strategic plan in April that will focus on licensure and supporting our emerging professionals, trying to get them to where they need to be to take the test. So if you have any suggestions that I can report back to the board from the licensing board, please let me know. We're open to thoughts. So that being said, do you have any questions for me?
Yes.
Okay.
So this is, and I agree with you, we need to have a clean copy of the QBS online because it does help our registrants not have to go through a bunch of redline copies for that. And then the question is for staff, when we get a registrant that calls in, what's our response to them about QBS?
So once, and I will make sure that the latest and correct version is up so it's no confusion. We would be pointing them to the website to what's available. We wouldn't still be able to answer specific questions necessarily or give them legal advice, but we would point them to that.
Okay, so our response is, here's this URL or here's this document, whatever it is, go look that information up for yourself. Okay.
Yes, sir.
I would like to go one step further on with this discussion, if we may. So recently, in the last 6 months, we had a situation where one of our large municipalities on the west end of the state put out an RFP, I believe. And they initially asked for fee. And when there was an uprising amongst registrants, they said, okay, back off of that, but give us a second envelope that shows us your fee. To me, it's still the same thing. It's still the same thing. But I want the firepower to be able to say, you can't do that. People want to argue and argue and argue, but I want the firepower to do that. And I don't know where to find that, and I'm on the board. Okay, so my recommendation that would help all of us, and I believe all the registrants in the state of Tennessee, and this all gets back to the health, safety, and welfare. That's why we're here. My recommendation would be that we as a board, or we as the A&E board and staff and our legal side, have some place where the registrants can go and get definitive answers. Now, I realize that we potentially, we may have had some of those before with the frequently asked questions or what have you. But when something's so blatant that I heard from 7 registrants on the west end of the state, I don't know how to answer them. And for me to say, go get your lawyer to determine this, come on. So I just feel like there has to be a better way for us to address this as a board. It puts us in a real predicament, frankly. That's all.
Is this something that we need to have? Is there an answer that we can give them that's different than that? I mean, again, the purpose of this whole QBS exercise was so that we could provide guidance to the registrants, and I got it, okay? But we're still got the same fundamental problem, is that we've got people out there that are blatantly violating state law. And our registrants don't want to get caught up in the backwash of that. And one of my jobs is the health, safety, and welfare of the public, but the other job is to oversee the registrants and to make sure that they do what they're supposed to do. And I just think we need to have a little bit more. I agree with you, Blair. We need to have a little bit more something, because ultimately it does come back to health, safety, and welfare. I mean, if you've got somebody out there procuring services going to low bidder and QBS is replete with all those kind of references, we are in trouble. Local municipalities are in trouble because they're getting in some cases, a substandard service. So, go ahead.
I was just going to say legal can't get involved in answering QBS questions from people that submit those to the board office. Like, all we can do is, like what Roxana said, is point them to. We can't answer specific QBS questions.
And we give them guidance if it's something from a municipality, that the people that oversee municipalities are the comptroller's office, and give them contact information to that. I mean, these are the people that are auditing.
Or reference them to the MTAS or CTAS.
Well, but they don't have any teeth to oversee. I mean, I know they give them guidance, but the people that really can bind them up.
They also provide legal representation, and their legal counsel knows that they would know what the QBS laws are.
I just think we need something on the other side of this too, because again, our registrants are getting caught up in making a decision between giving a quality professional service and violating our law. And I think we need to look at how our response is to give our registrants other avenues besides go read this document and you're on your own. I mean, paying a licensing fee for some reason, and some of that is to help go through the process of being professional. So I think we ought to discuss that at another board meeting or a session or something to see. I mean, I'm spouting off right now, but I'm looking at sort of a nodding ahead or throwing of a pen or whatever. Go ahead.
I'm just suggesting that if QBS, if you all are enforcing it, it would not be an opinion, but could you just state that if an RFP has requested a price to the registrant and say, if you proceed and you put a price on that, you will be subject to the board. And that way you're not giving legal advice, you're just stating the rules. Just a thought.
I think I understand there's some hands tied going on. Okay, I appreciate that, but the advice we're giving to our registrants needs to give them maybe a laundry list of things that they can go down and do to help remedy the situation. And I don't think we have that. We're not giving them that advice. Go ahead, Frank.
It's part of the problem, and I run into the same thing Blair's talking about pretty frequently, is the person that would be violating anything is the registrant. The people that are issuing the RFP shouldn't be issuing the RFP in the first place and putting the registrants in that position. And so that's the person that needs to be educated, if you will, for lack of a better term. So if something comes to you and somebody says, you know, I've received an RFP, and what do I do? Do you ever respond to the people that made the RFP? And I guess the question is, should they be the ones to say, you're asking these people to violate the law? I mean, is there any way to approach it from that standpoint?
Again, our office cannot give legal advice to outside individuals or instruct or answer questions the way I understand you are wanting us to be able to. We can't do that. All we can do is point them to the website and point them to what's there, but we can't answer those types.
But you're saying you could point the person that wrote the RFP to the website.
So I doubt that the person that wrote the RFP would reach us, right? It would be the person.
Somebody would,
unless they would report it specifically. An engineering firm or an engineer or an architect or a landscape architect or interior designer should report that to the board or to the professional society, and ultimately then to the board. And again, I think from most people's perception, the board is real or perceived the policing agency for this.
Before we go to let me bring this up here. I think too we may be looking at how we parse legal advice versus what we're asking for. We're not asking for you to give a legal opinion on something, but we are asking for a better procedural methodology to let our registrants and those that are around have a mechanism to go get these resolved with the full power and weight of what the statute says in Tennessee Code Annotated. And our registrants in a lot of cases are ignorant about, well, if a municipality is reaching out, what recourse do I have? Who do I contact? Do I contact this person or that person? Do I look at who's over these people? And we're leaving them out there basically to defend for this by themselves. And that's not a good process to go through. So I don't think we're asking for a legal opinion. I just think we're asking for a better procedural framework to go through the steps that need to be done to remedy these situations. Alton, I don't know if you finished your comment.
I did not. I understand, Ashley, and I agree that we can't give legal counsel to, I suppose, non-licensed professionals, but we can give more specific information rather than just or refer them to the website. Can we not refer them to specific components of the law that are contained in it? Drill down a little deeper than just referring them to the website. even to the point of showing them what the actual laws and rules say.
The information that they would need is on the website, and they also have access to the rules and laws through the website as well. Now, with that said, like I said, we cannot give legal advice to outside individuals. We can point people to statutes, and we do that frequently. But we also point people to the board website, like I said, which contains access to the laws and rules, as well as, I believe, a document regarding QBS is up there as well for them to access on the website.
And I'm really concerned that, a lot of these folks are novices at doing research like that. I mean, it would be much, much more, provide a lot more clarity and be a lot more efficient if we were able to coach them to the point where they need to go to get that information, or just provide it to them. The statute, the laws and rules specific to this say this. That's not giving legal advice. That's just telling them what the law says. Right.
In terms of QBS questions, we've been instructed that we cannot provide advice to outside individuals, and we are to direct them to the website, which contains a QBS document.
So, Ashley, I guess my question, I hope, is really easy to answer, but if not, please educate me. Should a complaint be filed against a registrant that alleges bidding on professional services for a municipality or other entity that is governed by QBS be found to be correct? In other words, the finding is, yes, they did bid for professional services for an entity covered by QBS. Would that be a violation of law by that registrant?
I can't give an answer to that type of hypothetical question. I can tell you that I have not had any QBS related complaints. I present all the complaints that we get to y'all. So, and I haven't had any QBS related complaints at this point.
So I'm not asking you personally. Obviously, I'm asking the answer from the department, or however you want to phrase it. I think that at this point, Mr. Chair, I'd like to have that as an answer, and I'd like to have it on the record as to, should a registrant be found in violation of the requirement not to bid professional services to an entity covered by the QBS requirement by law, is that registrant in violation of law? I think that's a pretty simple question, but because of the fact that we don't communicate with our registrants anymore, except by this circuitous route of go find it for yourself, I'd like to have that on the record.
So that's a request for an answer from the board. I think that's good. Yeah. Time's up next.
Actually dwell on it as much more, because Kathy kind of hit it. I was really going more a little bit back to what Ashley said, because really, since I've been on the board, this has been a really questionable subject. We've had a lot of committee meetings over the years and everything, so I think we're kind of understand legals, or at least our legals position that they're required to take. It seems like the only thing we can really do is kind of like what AIA actually said, is that let our registrants know that maybe I forgot, she said it better than I am, but some kind of way, just like, you're going against our statutes, whatever, by providing a bid for it. And only thing we can kind of hope is that eventually the agencies if we stop proposing for it, they'll say, well, why won't you do it? So, well, we can't do it. It's against our deal. And that puts us in a tough situation because that's our livelihood that they have the projects for. And if I don't do it because of that, but Frank does it, Frank gets the job. But, really right now, he's going to do it. No, but anyway, I don't know. I just think that that's probably our best position, I think, especially from our standpoint, that we can do. And anyway, I guess I feel like their hands seem to be pretty tied on what they can do. Let's just applaud. At least we got it on the website back up. That's one big step we haven't had in a year and a half or something like that. So anyway, that's all.
I just wanted to remind the board that we, in fact, have issued a penalty for that QBS violation of the QBS rule in the past. Now, I don't know whether it was whether it was signed as a consent order or whether it's in the process somewhere, but that has happened.
How long ago was that?
I don't remember, but it may have been before your time.
Other comments?
Is it appropriate for legal to research that and bring that back to us? I mean, maybe if they're not willing to answer some of the questions before us today, we could revisit what has transpired in the past relative to registrants being penalized in some form or fashion for bidding for professional services. And again, I mean, I hate to be a broken record about this, but this is why I asked about it last time and I asked for it to be on the record that we're not communicating with registrants. And to your point, so many of our registrants, when you look at the new registrants that are constantly coming into the state of Tennessee, we have this influx of new people who may or may not be as intimately familiar with QBS as we wish they would be, so that they could continue to do the right thing out of desire and education. And we can do all we want sitting here in this meeting, but we're not sending a newsletter, we're not communicating, we're not answering questions directly. We're just saying, well, why don't you go sue somebody? And I just don't think that's really in the best interest of the state of Tennessee and its citizens to suggest that answers that to me seem fairly straightforward should be encouraged to be settled in a courtroom. And I'll shut up now, but it gripes me that we can't get further down the road on this.
All right. Thank you. So we do have the one question, two questions to be answered, please, on the record for that. And go ahead.
In order for us to provide a memo on that, you'll have to make a motion specifically asking what questions that you want and the set of facts you want us to look at.
Okay. So do you have
some knowledge on the past? Can you ask for that? Can you ask? I asked you strategically while your mouth was full. That gave you time to think,
Since I can't make a motion, I thought it was safe to take a bite,
What was your first question, though, that you wanted an answer on? Okay.
I'm trying to think how to phrase it. If Steve's ready, I'll let him go first while I think of how to phrase it.
Well, I think my suggestion would be to, first of all, research situations where the board in the past has issued a penalty for the violation, for a registrant violating the QBS rule, which in essence, as I recall, on at least one case was a registrant gave a price in a proposal rather than a statement of qualifications. I don't remember any details on it, but that would be something I think that Kathy would be interested in. But overall, I think the suggestion is to ask legal specifically to issue a memo on how do we respond to questions from registrants about the QBS rule. Isn't that the real issue? Without just, can we be more specific?
I think so. Here's first motion. Okay, since you can't make one, I will.
Yeah.
We would like to ask legal to look at the complaint history against those registrants that have been disciplined by the board for violating the QBS statute.
I think it's a
Rule. Okay, but it's a statute. It's backed up by statute.
In
Yes.
Brooks Law statute, but we have a rule
So
about it.
So that's a motion, although by the chair, it's not a great thing to do, but I think I'm still, in some circumstances, allowed. So anyway, so that would be a motion.
I just want Ashley to restate what she thinks the motion is before we proceed.
May I make a comment?
Yes, please.
I'll do the best I can. In regards to QBS, we also need to remember that it involves any government agency that receives federal funds for the project, as I understand it. So I think part of the explanation needs to help clarify that if it's a municipality that's using federal funds and they're asking for RFPs, that it needs to be clarified whether or not federal funds are being used. Otherwise, I don't think the Brooks Acts apply. And anybody can correct me, but that's how I recall the circumstances. And I'll be quiet.
I think it's public funding. I don't think it's limited to federal funding. And most of the state funding is backed up by federal dollars anyway. But anyway, okay, go ahead, Ashley. The motion, please. I think that was the question, right?
So, as I understand the motion that you moved for legal to research complaint history of registrants who have been issued a penalty for violating the QBS rule.
Yes. Yep.
I think you said disciplined, not penalty.
Yep.
Discipline. Want to make that motion instead of me? It probably is more proper coming from
withdraw your
another.
motion.
I'll withdraw that so that it can be probably more properly.
Let's allow me to make that motion. So the chairman is not. He worded it exactly how I would have.
Just to be clear, because I know there was some discussion about the use of the word discipline, just want to make sure I have the exact motion that y'all are moving for. So, is it a motion for legal to research complaint history of registrants who have been disciplined for violating the QBS rule or been issued a penalty for violating the QBS rule?
Both, either or.
Disciplinary, yeah. All right, we got a motion. Do we have a second?
Second.
Any more discussion? All right, roll call, please.
Susan Ballard.
Aye.
Robert Campbell.
Aye.
Grant Minshew.
Aye.
Blair Parker. Brian Tibbs.
Aye.
Frank Wagster.
Aye.
Kathy Ware.
Aye.
Motion passes.
All right.
I'd like to make a motion. My motion would be that the board request legal to provide the board with an opinion of whether a registrant is in violation of law if they bid or otherwise provide pricing information to an entity in the state of Tennessee that is governed by QBS. They're governed by QBS, period.
All right, do I have a second to that motion?
I'll second that.
Any discussion? Those in favor, have a roll call, please.
Could we reread it just to
Yes,
make sure?
go ahead.
Right, Kathy, as I understand your motion, you are requesting that legal provide the board with an opinion as to whether a registrant is in violation of law if they bid or provide pricing information to an entity in Tennessee governed by QBS.
That is correct. Did I say that right, Steve?
Again, I think it's a rule, not a law. So maybe you should say rule or law, but
So amend, please.
Have a second? I did get a second. Okay, sorry. Any discussion? Let's have a roll call.
Susan Ballard,
Aye.
Robert Campbell,
Aye.
Grant Minshew,
Aye.
Blair Parker,
Aye.
Brian Tibbs,
Aye.
Frank Wagster,
Aye.
Kathy Ware.
Aye.
Motion passes.
All right. Don, I think, sorry for the getting caught in the QBS fray, but I think it was some important discussion, and I still think we're a little bit away from a resolution that we all feel comfortable with. So anyway, go ahead.
That was a good discussion. For the record, I'm Don Baltimore, General Counsel and Lobbyist for Tennessee Interior Design Education and Advocacy, abbreviated as Tennessee IDEA. I just want to thank the other associations and the board for all of the work and cooperation on legislation this year. We've been working with the other associations on legislation affecting the design professions that are regulated by this board, and hopefully all of our legislation will come out favorable to the profession and protecting the health, safety, and welfare of the public. Other than that, I really have no report to make.
Okay. Any questions for Don? No? Thank you very much.
Thank you.
All right. Now let's go to legislative updates, I believe.
Before we get into legislative updates, I've been asked to present you with information on the Open Records Act and Public Meetings Act. We've been giving it to all of the boards.
Okay. Would that fall in the agenda that we had, or do we need to have that moved to the end? Okay.
We can move that to general discussion if you would prefer. I just have to give you guys the presentation on the Open Records Act.
Okay. I didn't see anywhere on the agenda that we had gone through, so I wanted to make sure that we weren't improper in trying to insert it somewhere. I would prefer that we do it at the end so that we can keep on with the agenda. And for the record, I think Grant Minshew has left, right? So does that still leave us with a quorum with Susan? Okay. Okay. All right. So let's go to legislative update, please.
I have two things I want to talk about today with the legislative update.
Oh, I'm sorry. Time out. I just had a request to go to a break, and I ran right by that. And that's my fault. It's something. So let's take about a 5-minute break, and we'll go do our thing. Ask me, and I'm just sitting there going, yeah. So, okay, we're going to get right to this other thing.
What are you going to do? The Needham guy.
Engineering committee goes. I'll let you direct it. I mean, you're going to be making the report.
Chairman Campbell, we're back on the record.
Thank you. All right, so we have our legislative update is next, please. $41, and who we waiting on? Blair. There's back there. Okay. Susan, you still hanging with us?
I'm here,
All right.
and I can see you all on my computer screen. Everybody looks so wonderful today.
Thank you. All right.
All right, we have two things to talk about with the legislative update. The first would be amendments to the Right to Earn a Living Act. That is Senate Bill 0196, House Bill 0261. If enacted, the amendments would make several changes to the Right to Earn a Living Act. For instance, it would place a burden of proof on the department regarding, or on the specific board, regarding entry of regulations. It would allow the commissioner to intervene if a board makes an anti-competitive decision. It would also allow the governor to remove any board member who makes decisions that are anti-competitive. And the second item I wanted to bring to your attention is a bill regarding military service members and their spouses. That bill, as amended, permits active members of the armed forces or their spouses who hold occupational licenses in another jurisdiction to engage in their licensed profession in Tennessee without first obtaining a Tennessee license. The service member or spouse must be licensed and in good standing in the other jurisdiction. The amendment also requires the practicing individual to apply for renewal of their license either prior to the expiration in the other state or within 1 year of practicing in Tennessee.
We have some comments. I've got a couple. Unless anybody else does, I'll let you all read. So the first one is as we discussed a little bit yesterday, and I think you said it, Ashley, the burden of proof is now on the boards. What's the department done to educate the legislators on the negative impacts on the board, on the department, as well as on boards of this legislation? Because it does seem to be something that negatively impacts from a resource allocation standpoint, and it really does put things in a bind, and probably unnecessarily so. Okay, sorry, Todd, go ahead.
To your question, I think I'd probably be to respond to that. Neither myself nor Ashley would have as to what conversations our departmental people would have with the legislature. Wouldn't actually be involved in those conversations.
Is there some mechanism that the department is talking about that? Because again, as we discussed yesterday, there is a burden that this law puts on the department and our boards because of some of the caveats that are in there.
Those conversations would come probably from our legislative liaisons to the sponsors of the bill. And I know they've been up there. I know they've had conversations. I don't know the subject or the nature of those conversations.
The second one, and this is probably on the other bill for military, I thought we already had an expedited military, which I thought we worked pretty diligently on 2 or 3 years ago. Why do we have this back again in front of us? I mean, this just seems to be repetitive junk that we're going to have to come up with probably another rule to address this. And that just takes up time and resources to go do something that we've already got in place. I just don't understand the logic behind that.
Mr. Campbell, I can also respond to that. I recognize there is currently a statute that's already existing, which has to do with expedited licensure for military members and their spouses, and then also it talks about reservists and National Guard members who are mobilized and out of the country for renewals and continuing education. This bill addressed a spousal issue, which appears to be similar to the issue that's already passed in statute. So this appears to be supplemental in nature to it. Why it was introduced, I could not tell you. I do not know the intent behind it as to why it was introduced.
One last question. I think you said, and just want to make sure, this legislation is occupations and professions, right? Not just occupations. I think you said just, but I think the wording is occupation or profession, or maybe and profession. Because it's occupations, I don't care. I mean, frankly, because we're a profession, but I think the way the legislate, which I understand why they've got occupations in there. I think it's very, very short-sighted and incorrect to have professions in there. But I think the legislation does say occupations or professions, so I just want to make sure that's cleared up. I know we all. I read, I miss about 3/4 of what I read, so just want to make sure that I saw that right. All right, thank you. Questions, comments from anybody? Kathy?
This is just my naivete on the process. I just don't know enough about how we make rules and laws in the state of Tennessee. So I'm just curious, is the sponsor is Senator Kelsey, but is this a bill that the governor supports? Is this an administration? I mean, is this something that the administration does wish to more strictly govern our board and all other boards? I just don't know how this works.
It's not part of a departmental, what we call a departmental bill. It's not a bill that was supported, drafted by the department.
Okay.
Good, because again, my understanding was because of the North Carolina dental decision a few years ago, there was an individual within the department that had the ability to override decisions that we made that were restraint of trade or anti-competitive, and again, it just seemed to be repetitive to me, of that caveat in there. So, okay. Any other questions? Frank's trying to think of one to ask. I can tell.
Well, I think I have a comment on both of those bills. The military spousal bill, to me, might be problematic, but it's so rare that we would have anything like that, and so I have no problem with that bill. And I think if you look across the U.S., pretty much every state's getting a similar bill before their legislature. The other one I read and kind of frowned a little bit. But to be honest with you, I've got no problem with somebody looking over our shoulder on anything we do. And I don't think anybody in the state's trying to give somebody a license they don't deserve. And I've always thought, since we're appointed by the governor, the governor can disappoint us at any time. So, part of that. We could be disappointed, but why that was needed to be in a new bill, I'm not sure, because it looks like it could have been done anyway. But maybe it's clarifying something. But you said it put an extra burden on the board, and I was just trying to think. That's what I was frowning about, exactly what extra burden is being put on us.
Well, I think it opens us up for more legal action to be taken based on decisions that could turn into a long-winded thing that we don't currently have. We've got a little bit more separation from that.
I guess what Nathan pointed out earlier, The part of it that another part I was kind of frowning at this, if somebody wanted to contest not being, and I think I'm saying this right, or wants to do licensed work without a license, if you want to say it that way, they can take that to a court, and I think he said Grundy County, but anywhere.
Page 52.
Yeah, I hadn't got it in front of me, but that seemed to kind of make that a tough thing to deal with when it can be done on any court, and you wonder about the local. If it's a juried trial, and I don't even know if that would be a juried type thing, but if it was juried, you've got a local jury that has no idea of what they're listening to. I mean, it's kind of strange, but I don't know if our legal people have any comment on that one way or another, but probably not. Because these are bills before, legislature, not something they've come up with.
All right. Any other questions? I'm sorry, Kathy.
Yeah, Tony, if you don't mind, I am looking at page 52 in our handout that has the proposed law. It talks about how what was said earlier, the venue exists in the court nearest to the place of residence of the person filing the petition. So that's why they say, if somebody in Shelby County files a petition, then that in Shelby County, that's where everything takes place. And it says that within 30 days, they have the right to an evidentiary hearing, including testimony, argument, right to discovery is set forth in the rules of civil procedure. That's the place where you go if you're going to get, have a divorce, and everybody asks interrogatories, etc. So I'm just curious, Tony, does this, what risk does this pose to us as individuals that by serving on this board that we may find ourselves being compelled to attend these things? Is the state going to compensate us for this type of stuff? Has there been any study as to how much additional revenue is going to be required to respond to these kinds of things, or where are we on it? To me, it looks like kind of an open opportunity to spend a whole lot of taxpayer money responding to within 30 days, which is pretty doggone quick.
Trying to get some of my facts straight.
It's okay. Me too.
Right. So, with all types of litigation against a board, that's how that each of the individual board members potentially could be prone to having to give a deposition, having to give statements or affidavits. Normally, what we see is we designate an individual to provide answers in the form of depositions and whatnot as for the board members. It doesn't always work that way. So oftentimes there's one person that is designated to do that unless they want to seek an individual, for example, board member or administrator or whoever else to give their testimony on that. So it potentially could be individual board members, or it may not be. As to the compensation, quite honestly, I'm not really accustomed to answering questions as that whether or not the board members are compensated for the day if they have to go and answer these things. I don't know, Roxana, if the normal amount that is. No, Roxana's giving me a shake no. So so I don't really have a great answer to that. I would not expect much, if any. I think that so far is the cost associated with this. I believe this piece of legislation already has a cost analysis has already been done on it by the legislative fiscal review, and I think it was is it public knowledge that we can give out, Roxana? Yeah, I don't know.
Should have a fiscal note on it, though.
It should be on there.
That should be public knowledge, I think.
It should. Give me a moment. I will look at it, and if I can interject and tell you what it says, can I do that?
Yeah, that'd be great. And I'm not trying to get you to hypothesize stuff necessarily, but because of the very broad, I mean, this is the way it reads. I'm not an attorney, but I mean, the way it reads is that if citizen A says, "I'd like to challenge a licensing board, no matter what the license is for, other than we think accountants might have gotten out of this," then within 30 days, we've got to respond. And I think everybody here works, right? I'm just thinking down the road of how is that possible? I mean, so yeah, we give you time.
Right. So,
and again, I'm not trying to work you into a corner. I'm just curious.
No, it's just that I wasn't prepared to answer that question specifically. I don't haven't looked at the fiscal review on this in a long time, and the mechanism through which I look through these things is proprietary to our department, and so if there's a public facing of it, then it's something that can be released. But I do not want to disclose anything in public that
totally
is
understand.
Confidential to our department. I will say that if any of those things happen, if suit is filed, then this board would be represented by the Attorney General's office, and the Attorney General's office would do that representation. And if in that hypothetical situation where that does happen, there is a cost associated to the board with that, and it's costed back. It is. So if it does happen, I can tell you that there are costs. What a projected amount would be, I think that is the difficult part.
One other question. In general, is there currently existing in place, Tony, the process by which decisions of the board are reviewed regularly to determine whether or not the department thinks that the board is doing its job correctly or in accordance with what reasonable expectations?
Yes, there is a process.
So there's currently a process.
There's currently always a process. That is that piece of legislation that Mr. Campbell, you mentioned earlier. There is the supervising official within the department that does review all of the actions and decisions of the board. There's a process that's actually ongoing constantly.
Is it then, does this more or less duplicate that in a different format, in a different fashion of some sort? I mean, is this oversight of the oversight?
No, I don't think that's oversight of the oversight. I think that this piece of legislation speaks specifically to things that the board's action. It may not be a board action that they're doing in this piece of legislation. Might not be an actual action of the board.
What is it then?
Okay. So this piece of, and what I was referring to is that this piece of legislation is specifically talking about statutes and rules. Statutes and rules by themselves are not necessarily actions of the board. They're actions of the General Assembly. You all are required to enforce them. So to the extent that they would be asking, that a citizen out there would be attempting to file suit against an action of the board, that action would be based specifically on a statute or rule, and that's what they're attempting to modify.
Okay.
Not the action, but the statute or rule.
That is a great
See
point of differentiation. I appreciate that. Thank you.
Anything else? Good. Thank you very much. We get all these things that come up, and they get us a little verklempt, I think is a good word.
When did you learn that one?
That's what you got when you got teenage kids. So anyway, I think that's a Saturday Night Live. All right. Rules.
So at the last meeting on February 7th, 2019, you all adopted the regulatory flexibility analysis and a regulatory flexibility addendum on the proposed amendment to Rule 0120-0 Rule 0120-01-.03 parentheses 1, which would allow a person gaining practical experience in an office of a practicing architect to use the title, appellation, or designation architectural associate. Today, we are reviewing the rule for adoption and authority for a rulemaking hearing. We will need a motion and roll call vote to adopt the rule. We will also need a motion for the board to allow legal the authority to set a rulemaking hearing as soon as practicable.
All right. So the process is we have to set a date, or you will set a date, but we have to make a motion for you to set a date when that hearing is going to happen. And then a second motion, or just one motion.
So the first motion would be a motion and roll call vote. Adopt the rule if you want to do that. And then there will need to be a motion for the board to allow legal the authority to set a rulemaking. Normally, we would also have you adopt the regulatory flexibility analysis and referendum, but y'all did that at the last meeting, so you don't need to re-adopt it this time.
All right. So do I have a motion for those? And first of all, let's have a motion to adopt the rule as presented to us. Okay. Second. Crappy motion, but
I thought it was good. So
yes, do we have any discussion? And this is on the motion to adopt the rule as presented. No discussion. All those in favor say aye.
Aye.
Roll call.
Oh, that's right. Okay, I missed it 3 times. I got it. Sorry. Find another chairman, please.
This one actually has roll call anyway.
It does have roll call anyway.
Susan Ballard,
Aye.
Robert Campbell,
Aye.
Blair Parker,
Aye.
Brian Tibbs,
Aye.
Frank Wagster,
Aye.
Kathy Ware.
Aye.
Motion passes.
Thank you. And the next one is, which I think Frank wants to make, is a motion to set the rulemaking date.
I move that we set the rulemaking date.
Second.
Second.
Authorize legal to set the rulemaking date.
Close enough.
I move that we authorize legal to set the rulemaking date.
Okay. And is my second okay with that?
I'm good with that.
All right. Very good. Any more discussion? Can we have a roll call, please?
Susan Ballard,
Aye.
Robert Campbell,
Aye.
Blair Parker,
Aye.
Brian Tibbs,
Aye.
Frank Wagster,
Aye.
Kathy Ware.
Aye.
Motion passes.
Thank you very much. Next thing on rules, just to make sure, we will. I know we're going to have engineering committee will have discussion on definition, which will take some time. We also have the rule that we discussed yesterday that we probably need to get out to us to look at. There were a couple others that I thought we may have discussed during engineering committee that we need to get in front of at least the engineering committee right now to start the process of our next set of rulemaking process. So, and I don't know if this is the correct time or not, but if we may need to look at an engineering committee meeting in between, either next month or
Special call.
because it's again, what we talked about yesterday with some more rules that we need to discuss, and we didn't, the definition part, just in our committee, that we need to still talk about some more. And I know more, but I think somehow we're going to have a little bit more or some other time, and whether that's a phone call. We would, I think, prefer to do it face to face if we could, and we're committed to finding a date to get together to do that. But But before I left this and forgot that, I was going to bring that up.
I had a question if this would be a possibility. And the June meeting is June 26th, 27th. I wanted to make sure that we all had that because we had to move it for the annual architects meeting so that they can all be here with us. So we did all agree that June could be moved to the 26th, 27th. What about an all-day Wednesday engineering committee meeting? Would that work out for the engineers as opposed to just the afternoon? And would that give us enough time since you're here anyway?
I think that's probably a little bit more of what we need to look at doing because, I mean, we've got several things that I think we need to discuss in the rulemaking, and this definition thing is going to take a pretty good amount of time in addition to the normal.
Okay.
Sounds reasonable to me.
So I'll move toward that, the Wednesday meeting, instead of it being just the afternoon, focusing on getting some drafts of the rule language and anything else we can in advance for that to be a full-day committee meeting. Thank you.
Not to be wanted, want to be left out, but are these discussions that you're having on rules, is that engineering related only?
I think the one we did yesterday was the one we looked at yesterday was a document that we use that need to be made into a rule. That was one, but we probably ought to get the list of them together and definitely there were a couple other that I thought about. I think we talked about in the committee meeting that may need to be vetted. They'll definitely be vetted by everybody, but we probably ought to have some others too if there's others to be brought up at that time.
If there are issues that relate to everyone, I'd like to be a part of that.
This note one was a thing that we typically use in our engineering committee, and let's make a suggestion. Let's look at what those are, and when we come up with it, we know the one. I think again there were 2 or 3 others, and if they are things that relate, then let's open up some time maybe at the end of that meeting to where we can all get together.
Robert, one of those was a sort of a draft of a rule that would grant us a little more flexibility in the evaluation of experience. So that which would relate to all of the disciplines.
Yeah, what I was thinking is, since y'all were talking about an all-day meeting, if you had something that involved everyone, maybe like later in that day.
I think that's great.
We could show up at 3 o'clock or 4 o'clock or whatever.
Go ahead. I think good question. Ashley, go ahead. I'm sorry.
Oh, you're fine. I was just going to say, as for the progressive experience rule that you were discussing, I do have a copy of that guide to provide to the other board members. I know you already have a copy of it, but we do have copies to provide to them if they would like a copy.
Yeah, I think that's good to send just to let them know what we're doing. But there's a few other things too that probably go I think most of them are, well, I shouldn't say that. They probably do have some tentacles in some other places too. So definitely not trying to keep you all out of there, but I didn't want to waste your time by having us talk about
actually a good recommendation
certification thing. So, okay, go ahead.
And at the same time, there are several areas in the landscape architectural side that we know we want to clean up or add a little bit of flexibility in there. So this may be that opportunity for us to put something.
But we may just want to have that session at the end of, like you said, if it's at 3 o'clock or 2 o'clock or whatever, so that we can go through. Because I know we're going to take up a pretty good chunk of time just with the definition, and then we can kind of move into rules later on. Sorry.
Would you like for us to go ahead and pass out a copy of that guide, or do you want to wait till the end?
If you've got it, that's fine. That's fine.
I think we will also need a roll call vote on that second motion. I don't think there was.
Okay, I'm sorry. I thought it did. Okay.
Is that the one that you did? I think that was it.
Okay, never mind. Y'all did roll call vote. Just want to make sure.
No problem. No, thank you for keeping me in here. All right. We're good on rules. We're going to try to obey them this year. Okay, good. Director's report then, Roxana.
Thank you. I believe we start on page 82. Give me a second. Yes. The first thing you're used to seeing, that is our complaints, administrative complaints open, not many in February. So now I will only have the 2019 ones. We would need a motion to close. These are the letters that we send out, renewal issues, those kind of things. This meeting happened so early in April that the March report wasn't really finished for me to add it. So in our next meeting in June, you'll see a lot more, because by then we're far into the month that we will have all the way through May. So that is for the letters of caution that I would need a motion, please.
That's on page 82 of your iPad.
Correct.
Make a motion to approve letters of caution.
Second.
Second. Do I have any discussion? All those in favor say aye.
Aye.
Roll call.
Susan Ballard, Robert Campbell,
Aye.
Blair Parker,
Aye.
Brian Tibbs,
Aye.
Frank Wexter,
Aye.
Kathy Ware.
Aye.
Motion passes.
Thank you. The next item, I don't think we need to vote on. We presented this at the last meeting and I think liked it, so I will continue. This is that general metrics, if you will, of how timely we are with our complaints. So for the month of February that was closed, we're at 100% within all the professions, of total of 104 cases within that pipeline. So that's just information and not new, but you'll get that each time. The next couple of pages are new. I don't think we need a motion, but if we do, we'll make that statement. This is a version that I think we can put on the website, so I do want our eyes kind of on it. We had talked about, and I've always agreed with Kathy's point, that at least if we can put the discipline that's out there that's easily accessible and available to do so. As the board knows, the disciplinary action report has always existed. It is how complaints are put out for all of our regulatory boards, but it's on a month by month. It's not that easy to research. It's hard if you are just interested in A&E or specific to engineers to find it. So this has the complaint number. These are all the closed cases. So the reason you're seeing the names is obviously if you did the disciplinary action report, you'd be able to see it. It's all of ours. The activity at the very end is the number of days. It does not give a full, any kind of summary of the case, but it does give the disposition, and then there you can kind of see if it's a consent order, letter of caution, and so forth. So any ideas on this? Are we good? This is all of 2018. So that's why you're seeing quite a bit, but it's everything from January all the way to the middle of December that would have been closed and available for public review.
A couple of questions.
Yes.
What does the activity code mean? What is that? Is that in day? What is that?
Walk me through which column, if you don't mind.
The last one.
Oh, the activity. Okay, so that is kind of the aging of the case, how long it took to close it. So if you look at your letters of warning and instruction, especially on the second page, you're going to see zeros because we can turn around and close those. You give us authority to close them. We make it official on the record. But you've got some cases, the ones that are higher, possibly would have gone to an administrative law judge or litigation at the end.
The other, go ahead.
And I could take that column out if we find it confusing. I mean, at the end of the day, the only thing we can present is what's been settled and closed, so it may be confusing to list it. The close date is right next to it. So you see an open date on the first one of July 6, 2017. It didn't close till almost a year later.
And I guess the other thing I would like to see, and if you could squeeze it in, maybe take that one out, is whether this is an engineer or an architect or a landscape or interior.
Perfect question. So the second column where it says client, that tells us what it is, but that tells me, right? I know what the codes are. You all don't. So in my recommendations of this report, I would like to replace the codes with the word and still be able to fit it. And obviously, if I get rid of that column and it still has to be readable, That's exactly how it'll be. Instead of 1202, those are our engineers. 1201s are our architects. The firms are the 1205s and so forth. So we're going to replace the number with a word. So that sounds perfect. I think it will still all fit if that's good with the board. The order that we present these, so this is all of 2018. Right now I've got them in the date order of the case. So if it closed in December, would you prefer them by profession? No, doesn't matter. Okay. Okay.
When was the last time that we made this information readily available to the public? This type of information?
It's available to the public every month on the disciplinary action. Just like this, possibly never.
When have we made it readily available via the AE website or something that is more closely?
It has not been.
Not
it
ever.
Has not been on the.
Not ever.
No. Your newsletter, if I'm recalling the last time that I saw it, had discipline information, not exactly like this. So this would be new. I can obtain this for 2017 to look very similar to this and post both years if that's what the board would like.
That's what I was wondering is if we want to go back more than 12 months simply because we haven't done this in so long that 2017. That's just that for discussion, but that would be something I would ask.
Yeah, I think the consensus of the board is let's go do 2017 and 2018. And now, would this be? How would this look on the website? Would it just say complaint data as a tab that somebody could go click on and open up a PDF or something? Okay.
Just like you're seeing it, other than I'll put a title on it, a date of when it was posted, or from January 1st, 2018 to December 31st, 2018.
So you could have multiple. You would have 4 or 5 years potentially.
Eventually, yes.
That would
exactly
stack on top of each other. And you click on 2018 or 2019, whatever, and we could this. Okay. I think that's good information again to be able to see who has been disciplined. And I think it's a deterrent as well. When people look on there and see somebody they may know, they go, oh, well, okay, somebody's paying attention. And sometimes if it's not in a black hole, that does create a deterrent.
Yeah, I agree. I just want to say it's not intended to embarrass anybody. It is exactly that, so that registrants understand that there are potential ramifications if they aren't following the standards.
Just as a comparison, the state of Kentucky, the Board of Engineers and Land Surveyors actually puts theirs in their quarterly magazine with all the details about and no names redacted.
Well, when they're closed, that's why this isn't, because the complaint is already always available to the public. While it's in the pipeline, it is not, but these are closed cases.
I think that's good. Yes, thank you.
Welcome. Okay, the last item on my report regarding financial data, we had said that our numbers would be leveling off some. I've got the report on page 86 that Mr. Parker does have our landscape architect listed now on it. So thank you for pointing that out. That is all 4 of our programs, leaving us, let's see if I can see, with a total surplus of $231,838, and I believe we are now kind of done with the big expenses and more at a level amount. The breakdown of the expenses is on the next page if we wanted to kind of look at the different categories. And this only includes through January. Again, we were so close to the beginning of the month that the month of February and March is not there either. But we'll definitely have a better picture by our June meeting. Actually, we will probably even have May closed by June. Yes.
I just have a question.
Sure.
So what is included in state professional services, the bottom line on the expense side, the line item for 33510120001 for state professional services? I assume that's some type of internal support, but what's included in that?
I think 725 includes even items such as the billable amount of rent that we pay. So each program is billed for general services and things provided by the state. And that's the category under which we've always seen that. maintenance on machines, anything along those lines that are shared expenses for the state.
Is that a percent of revenue, or how is that computed? I'm just curious.
So that's a really good question. The last information that I have is it's based on licensing pool. So the bigger boards are going to pick up more of a piece than the smaller boards.
So it's a dollars per registrant?
Yes.
Okay.
Yes. And so it's expensed that way. I know that we've talked a couple times about the changes that the board staff and working from home, which is awesome. So that in that particular category, due to that, we will see a savings as far as being charged for office space and things around that nature, because right now we're going to be sharing space and only here in the building 2 days a week. That would fall in that category. But yeah, a lot of expenses are based on our number of complaints and number of licensees.
Any other questions? All right. Good deal. Thank you.
Welcome. I think we've got 2 more items, and I want to make sure we've covered the June meeting so that everyone knows that date has been moved. Separately, we did at yesterday's meeting, and just as a follow-up, I have the 2 national organizations meetings. I want to make sure that we don't miss anything at all. We'll start with NCWS annual meeting. I think we put something regarding their agenda for you to review. So the way we have the NCWS request for the August Washington, D.C. trip, and it's either the December or February meeting when we voted, we have the 3 funded members as Kathy, Alton, and Steve. But my records indicate that we wanted to possibly request that the others attend as well. So I would like to, since now's that crunch time, make sure that that's the case, that those that are funded are able to go to the August meeting, and those that are still interested in having the state fund, that I have that so that we can get that request put in writing. I don't know that the 2 funded members will be approved, but now's the time for us to finish moving that.
When did you say the annual meeting was?
14th through the 17th of August.
Okay.
Are you going to that one, Roxana?
I am planning on going to the annual, yes. We've got until May 3rd to make sure and turn all that in, and that is correct, Alton. Thank you. It's August the 14th through the 17th in Washington, D.C.
I mean, I would like to go again. Obviously, still continue whatever of me being on the board at that time. But yeah.
So are we going to go ahead and definitely still include Kathy, Alton, Steve for the 3 funded members we know are going to be approved, and then ask for both Ricky and you to possibly be approved and funded by the state? Okay, those were my notes. So we'll continue with that. And since May 3rd is around the corner, as soon as I have an approval or information on these 2, I will get directly with those board members to let them know that this is approved, so you can make the reservations. Okay. And then the NCARB, I believe we have completed all of that. Their meeting is in June 20th through the 22nd. We have that as the 2 funded board members and Mr. Tibbs approved by the state to be funded, and that justification, because it's closer, it's right around the corner, has already been moved and approved. And your registration can be paid by the state, so when you register, just mark that a check will follow for yours, and the funded members can do their own thing. So that's, yes, I think everything that I have I missed anything? The 19th? Okay. Yes, their meeting is the 20th through the 22nd, which is why we moved our board meeting from June.
Stating again the June meeting, our June meeting.
Our June meeting is the 25th, which is a Wednesday, so that would be the engineering committee only, unless we change, and I would send out information early in advance to see if the other committees need to meet late afternoon, and the 27th is the full meeting.
Well, Roxana, also, in the tail end of the engineering meeting, we talked about bringing in the other.
That's what I said. Yeah.
Yeah,
possibly
not just
that Wednesday.
committee meeting, but okay.
Yes.
Thank you.
Yes. It's June 26th and June 27th. There are no other questions. That is all that I have, and we would
Very good.
be ready for the committee.
All right, thank you very much. All right. Yes, ma'am.
All day Wednesday, you want hotel reservations for the night before?
I would prefer it. I just hate to try to chance coming into Nashville in the morning. I've had that bite me a few times. When you're doing Bo and Luke Duke maneuvers on the interstate to try to get here in time, it's really not that. All right, the engineering committee meeting is next on our agenda, and I'm going to turn this over to our engineering committee chair, the Honorable Alton Hitchcock, as he used to be called by some member of our board.
Thank you. I would point out he's no longer here not because of that. Let's see. We had 9 reviews for either application for registration by committee or by exam. We took a very long time in processing through those. One of those in particular is of somewhat keen interest. It involves an applicant requesting reinstatement following an offense that would require the full vote of the board for reinstatement, not just the approval of the engineering committee. I will say that the engineering committee heard the applicant yesterday, and the engineering committee, after consideration, is ready to make a recommendation to the board for reinstatement, but we felt like it would be important to give the registrant or the potential registrant an opportunity to come address to the full board the issues and the process that he went through. So with the board's permission, we'd ask Mr. Needham, if you would, to please come forward.
Red button again. Okay. My name's Jason. I want to thank the engineering committee for meeting with me yesterday and the opportunity to talk to y'all today. I've lived my life a certain way to be honorable, truthful, to try to follow through on what I say, and to help others above myself at all times. But over the past couple of years, I've learned a very valuable lesson that's hurt all aspects of my life. I learned that it is more important. It is just as important to do things right, but the way you go about doing them, the process to follow through, the process to complete the details is just as important as the commitment itself. In 2013, I left and started my own firm, and then in 2016, I was paid a visit by the FBI. The FBI came into the office. I immediately cooperated. I gave them all the information that I knew. I denied nothing. I accepted responsibility. I explained the process. I told them how I did it. I even showed them where the files were and what the files were about. I pled guilty to 1 count of accessing a secured server in April of 2017. And then in August, I was sentenced. For the past 18 months, I've spent my time volunteering in the education department, teaching others my mistakes and helping them improve their lives, whether it's in high school classes or college level classes. The questions that the committee had last time, I want to go ahead and address those. So I'm sure y'all might have the same questions because I don't know how familiar you are with my case. I worked for a company from 1986 till 2013. I was from 16 years old till then. It was a family to me. I was committed to help them in every way possible, but not only them, but the clients. I've always put clients and commitments above myself, and it's at this point to my detriment. When it was a very hard decision to leave, when I left, I still felt a commitment to help the architectural clients, the commercial clients, and the staff of where I was to complete the projects because I was their point of contact before I left. I still had the passwords to their open side of their FTP server where they share files to people. I was informed by the FBI that regardless of the intent, that is a felony. That just the access to the server breaks a statute. So at that point, I stopped professing myself to be an engineer. I knew I stamped no more drawings. Then once I was sentenced and once I pled guilty, I notified the board immediately and gave it my license. And today I humbly request to be reinstated. If you have any questions, I'm more than willing to answer any questions y'all might have.
A couple of other pieces of information that the sentence has been served, the restitution has been made. One of the things that the applicant has also done is kept up his continuing education requirements. Those are current. I'll leave anything else out.
I mean, there are no outstanding probations or anything else from the sentence.
And I want to reiterate that the engineering committee is recommending reinstatement, but it does take a motion and a roll call vote from the board.
All right. Thank you, Alton. So it comes to the matter in front of the board for motion for reinstatement. Or is there any questions to the applicant? Any things that come up from anybody?
I know you guys, and I know you've asked them every question in the world. So,
but if you've got one that you don't think we asked, that's fine.
But given what I've heard and what I've heard from Alton is, I move that we reinstate his license.
Okay.
Second.
Got a second? Is there any other discussion from the board? Anybody? So let's have a roll call, please.
Susan Ballard.
Aye.
Robert Campbell.
Aye.
Blair Parker.
Aye.
Brian Tibbs.
Aye.
Frank Waxter.
Aye.
Kathy Ware.
Aye.
Motion passes.
All right.
Very much.
And Jason is one much greater than I said. Go and send no more, please. All right. Thank you.
All right. Proceeding on, one of the things that we've found or seen in these multiple reviews, as y'all know, when only the board members can actually vote on whether or not to allow somebody registration by either committee or exam. But in an effort to try to ensure that we treat everybody equitably and fairly, one of the things that we're trying to do now is to review these guidelines and ensure that we ask the appropriate questions and review with these guidelines in mind. The other thing that we have found is in
Alton,
this. I'm sorry.
You might want to say what this exactly is.
Yes. Okay. Thank you, Kathy. At the time, it was what it was handed to us earlier by legal staff. It's at the top upper left-hand corner. It's labeled engineer intern certification. But as you can see on down, it also goes into professional licensure requirements, including practical application of theory, management of engineering, communication skills, social implications of engineering, and so on. So, again, we try to be cognizant of what these guidelines establish for practice when we consider whether or not the experience is appropriate to allow somebody to either sit for the exam or apply by committee. We also recognize this and other issues that there may be, we should consider a little more, the introduction of a little more, for lack of a better term, common sense. For example, I think Robert pointed out yesterday that if somebody's got 30 years of practice experience and there's some little nuance that doesn't allow us to make a recommendation for comity registration by comity, we ought to be able to exercise a little bit of common sense in that determination. And so we've asked the staff to help draft modifications to the rules that may grant us some of that flexibility. And those are some of the things that we want to talk about in this engineering committee next time, that we would want to integrate all the other disciplines in. And again, the ultimate goal, as Kathy so articulately stated, is how do we get them to yes? That ought to be ultimately our goal. And maybe not, I'm not sure we're supposed to give them counsel or guidance, but we'd like to be able to do that, not just tell them no, but help them understand where the deficiencies are and what specifically they may want to do or target to, again, get to the finish line. We, at the upcoming, in the May NCAAS meeting, they have proposed modifications to the bylaws. Most of those are administrative in nature. There's not really any, there doesn't appear to be any significantly meaningful bylaw modifications. We'll know more about that. We've got copies of that, and we'll know more about that and report it back, I suppose, at the June meeting, what was done and what those bylaws mean. Our extinguished chairman, I'm sorry, distinguished, what did I say?
Extinguished, but that's good enough.
Okay. Recently attended the 2019 NCAAS Board President's Assembly and came back and provided us with a significant amount of information. Took up half the meeting listening to Robert. I'll let Robert, if you want to, just to give a brief synopsis of the meeting.
You have a time limit.
Yes. Please limit that to 30 seconds.
First of all, it was the best 4 hours of Alton's life. But besides that, Alton went through most of these. I'll tell you, and you see kind of why we're looking at some of these rules. One of the things they talked about was, as a threat to licensure, it's our mobility, which I know NCARB's got a little bit better model for some of that. But that we don't have, but trying to take some of those barriers down state to state. We've got the master's degree that always seems to kind of pop up, and we've got our own heartburn with that, but there are some states that are using some mitigating factors to try to balance out what they see as deficiencies maybe in the undergrad versus the master's that we may be able to do. A key part that we had, and again, I know you guys look at stuff when it comes to some of your international applicants where you've got agreements, but there's this thing called the Washington Accord, which ABED is actually a signatory on, where different countries are listed in part of this accord, where they get audited every so many years. And what it does is it helps to set a consistent educational standard for these countries that would be consistent with what we would look at in the U.S. And that may be something that we can look at some of our international degrees and make sure we've got an educational equivalence, so we're not having to go through a big gyration of trying to look at credits. And we're going to take some more look at those kind of things, because frankly, I don't know that we are aware that some of those agreements have been done at a pretty detailed level over the years to try to standardize.
Fact, that some of the accreditations don't always match NCAAS requirements.
So anyway, that's part of what we're wanting to talk about in our rulemaking hearing, is some of those things, as well as this is a guideline and we need to make it into a rule. We kind of found out yesterday that anything that we use de facto to make decisions on probably needs to be elevated to a rule status instead of a policy or guideline status. So we're trying to get some of those things back in the mainstream of the rulemaking part of it. So that's all.
I also talk about the schedule for computer-based testing for the PE.
Yeah, but that's just. I mean, there's a bunch of stuff in there that people can read if they want to, but it's just schedules for that. So I don't want to take up any more of Brian's time. I don't care about Frank's. He's fine.
We had an interesting question from an employee of Oak Ridge National Laboratory that one of the engineers inside the organization threatened to expose any engineer that practiced or was supposed to put his seal on something that was a document related to their practice, that if he didn't put PE followed by the state of his registration, then it was a reportable offense. And the request came from that employee asking, is this real? Can they actually do that? Well, as it turns out, that it is true. Rule 0120-01-.031D specifically does state that. What we had decided yesterday, the other question was from this engineer, I think he was registered in 8 states, and he said, if I have to put all 8 states on there, it seems sort of braggadocious and irrelevant. I think what we had decided yesterday is if you're not registered in Tennessee, if you put PE, the implication is that you're registered in the state of Tennessee. If you put PE and you're not registered in the state of Tennessee, then we would like for you to put PE followed by the state, your home state of registration, followed by your home state of registration. Does that make sense? Yes, exactly. We meant to talk extensively about the definition of engineering. Unfortunately, because of the caseload with the applications for registration, we were not able to get to that, thus the request for the special meeting, a special call meeting. And then the final thing was, and Roxanne has already announced it, about NCAAS's annual meeting. Did I leave anything out? It's a lot. It's a long meeting. Thank you, Mr. Chairman.
I have one follow-up item, yes. On our applicants, we left a Mr. Robert Leon Lubers kind of pending for a final decision from the state of New Jersey. I've been checking my emails all morning, and I don't have a response yet from the New Jersey State Board. They might have been out or not, playing catch-up. So
I was assuming you had a good excuse, and I wasn't going to throw you under the bus. But thank you for...
Wanda got it out. She did fantastic, so we just don't have a response. So as it stands, we have 2 options. We can leave it as is and bring it back in June, or if the board, the engineers are comfortable, once we find out that it truly is closed, is the board then comfortable, or are the committee members comfortable letting us proceed?
This is my opinion, and let the other members of the committee weigh in, but I would be comfortable if you did determine that it's closed for legal to process it beyond that.
I agree.
I've already forgotten the specifics of the case, so I defer to y'all.
This was that civil penalty that we knew the penalty had been paid, but it wasn't clear from the consent order,
Consent order had been
that
closed,
it was completely
but I
closed.
just don't remember anything beyond that. But whatever they say is fine with me.
So if they say it's completely closed, you're okay? Okay.
Seems to have unanimous consent.
Okay.
That's all. That's the end of my report.
Okay, before we go to, and I assume we're not going to have the grant.
I actually have an update, and with Susan there, I think it's okay for me to give it because it isn't really on what's happening next year, just an update that I need to give the full board.
Before we do that,
Yes.
did you have some information on definitions that you want to go over?
I can. I mean, I can talk about what the committee did if you want to do that.
Don't let me forget on the engineering committee members for Mr. Lubers. Before you leave, you will have to sign that
Sign
you
that.
approve if that's met.
Okay.
Do we need a motion as well? If they're signing this? I don't care.
I think if we can sign it and put a disclaimer at the bottom of our,
Perfect.
and that's what we've done
We'll
in the
make sure to
past,
do
that if this condition is met, then go ahead. We've done
Perfect.
that with others.
Perfect. Thank you.
Kathy, I know you all met, and I think Frank was there too, and several others, Blair. But go ahead and give an update if you don't mind. And I apologize to her. I jumped in the middle of her definition update yesterday and got cranked up on some other stuff, so she wasn't able to
That
finalize
never
that with us.
happens. That just never
We did
happens.
yesterday.
Yeah. Well, thank you. Let me just give a brief update on where the committee is. So the committee consists of Blair, Frank, Kathy, and Susan. And we had a phone conversation via the conference call process with that the state facilitated, and it was advertised as a public meeting so that we didn't run afoul of any of the rules and laws relative to public meetings, government and sunshine. Basically, what we discussed was, and those of you who are here, if I say anything wrong and misinterpreted or wrote it down, y'all please correct me. But generally speaking, Blair said that ASLA was aware of this issue, but that he personally was maybe on the fence as to whether or not there should be a definition, and his group was kind of on the fence as to whether or not there should be a definition for landscape architecture. Frank said that 90% of the practitioners of architecture were probably neutral, and that he also was kind of trying to decide if that was something that was really needed, and even suggested that maybe we needed a formal attorney general's opinion from legal, and we didn't ask for that, but that was just part of the discussion.
Yeah, one thing.
Microphone. Sorry.
One thing, there is a definition that the AIA has. It's very similar and almost the same as the NCARB.
I'm gonna get to that.
Oh, okay.
That's okay. That's okay. But I'm just building up to where we are on all that. Go ahead.
I was just going to say that the NCARB is presently looking at that and in the process of possibly rewriting it, which the AIA probably would go along with whatever that is. So that may delay whatever decision we might be able to come up with.
Yeah, and I think that's kind of the general consensus, is that this is a somewhat in a state of flux across the country for a lot of different reasons. Susan, I think, is still there. And Susan, correct me if I'm wrong, but you said that you were in favor of a definition for interior designers. And I represented the engineering committee. And generally speaking, I think we feel like the populace at large for engineers is really not terribly concerned. However, we don't want to be seen as having a barrier to competition. That is not it, so much as that it's been pointed out that it would be helpful in some cases for legal to have a definition, or for people who are reviewing these things to be able to point to a definition of engineering when cases come before us. So we're not there yet. We're still in the talking phases. I don't think anybody had any firm position, except for Susan. Susan did say, is that right, Susan?
That is correct.
Yeah.
CIDQ has written a definition that's been approved by our organizations, and that's what we would like to move toward.
So landscape architecture, CLARB has a model law, and ASLA has a definition that it is very broad. That is at the national level.
That's correct.
Architecture, NCARB has a definition, and AIA would probably go along with that definition, but as Frank just pointed out, that's up for discussion now at the national level. The interior designers, Susan presented actually at our last meeting the 2019 CIDQ definition. We previously looked at that. It hasn't been adopted, but that's out there. And the engineers, of course, we were given a document by Ashley. Thank you, Ashley. It's a very good document that summarized literally every single state. And I think when I looked really, really carefully at all the different states. There are as many definitions as there are states, so there's a lot of opportunity there. The other things we talked about were the fact that we need to get all of the stakeholders lined up. If we're going to have a rule like this, is a pretty big deal, and so you definitely want to get your stakeholders lined up and make sure that they're behind it. For the landscape architects, that's of course the Tennessee chapter ASLA, the School of Landscape Architecture, CLARB, Susan's group ASID, IIDA, the deans of schools with ID's degrees, Interior Designers Society, and the National Council for Interior Design Quality, I think, if I get that right. Susan, forgive me. Qualifications, okay. NCIDQ for architects, in addition to AIA and NCARB, UT, U of M, Belmont. I think those are the three schools, is that right, that have architecture degrees?
Belmont does not yet.
Not yet?
But they are pursuing it.
But they're pursuing it, okay. And then for the engineers, of course, we're all over the board with so many different groups, but NSPE, TSPE, ACEC, ASCE, SEI, ASHRAE, IEEE, the deans of the engineering company. And then I wanted to point out, too, that we need to get the professional liability carriers involved so that we don't suggest to the registrants a definition of engineering that the professional liability carriers would not cover in the practice of engineering. So, having said all that, and also Ashley gave an overview of the rulemaking process, and we believe that is the way that we would proceed forward, not a law change, a rule-making hearing. Yes, the net out was we need more time, we need more work, we need more discussion, and that's not new. But because we did not have the time for adequate discussion yesterday, the engineers committee in general felt like, and we've already said, we'd like to have more time. We can't squeeze it all in when we have things like hearings and on people's careers and that kind of stuff. So I'd like to make a motion that the committee. Well, I don't know. I probably don't need a motion. Do I need a motion? The engineering committee is going to discuss this, right? Do we need a motion on any of that? Okay. All right. Do any of you all need a motion relative to definitions of your various disciplines? No? Y'all good? Y'all want to join in with the engineers for further discussion?
Absolutely.
Okay. So if you can facilitate all of that, Roxana, that'd be great on the Wednesday of the next meeting in June. I don't think there's anything else. Any questions or any insights or inputs y'all would like to give at this time, except Robert? He was a guest on our phone call. That's why I said that. So he had his chance. No. Anything you want to add, Robert?
It seems like you really want to make a motion, though, so I'll not say anything after that.
No.
You've begged for a motion here for
Nope.
5 minutes, so I'll just be quiet.
All righty. That's all I have. Thank you.
Thank you. Good report, and it was a good meeting. It proves that we've got a long way to go still before we get there. So, all right. Now, grant committee update, please.
Thank you. And I will try to keep it simple, but I did think that one thing was definitely worth addressing, just as a quick summary. And Susan, I know you're there, so thank you for being available. My plan is for the next round of grants to send out those letters in May, very similar to what I did last year, to make sure that everybody had a chance to send us their proposals, their requests. So you and I can touch base on that as well to make sure that we get as much as possible for the June meeting. So that will happen. What you have on your iPads on page 100, and you can stay with that letter and I'll be happy to explain. This is relevant to the 2017-2018 grant. So these would have been the grants that were distributed or at least looked at before my time, but that should have been spent by the summer of 2018. So this letter is from the Tennessee State University. It's the engineering program. I received receipts from all universities probably by October. There were a few stragglers by November of 2018 that were still sending me the receipts. The backup to what we approved was handed out. I had not gotten TSU's. So there's an email probably way back here from December. The first response I received in December was finally an apology that there had been some turnaround in staff, no administrative staff to help pull those receipts, an apology that I'd get it soon. So long story short, I did finally receive this letter, and I believe in January or February, an explanation that the equipment that they had asked for and you all as a board approved was not actually what was purchased. And so at that time in January, we were already in the round of the next set of grants that I consider the 2018-2019 period that you all approved in October to go out. The contracting legal team said, and I agreed, and I did talk to Susan at that time, without receipts for the prior grant and with the equipment being slightly changed or significantly changed without this board's review and approval, we could not distribute the next grant to them. So anyway, so that's where that stood. The amount, I believe, was $19,973 that we would have distributed. That got held back because we had no receipts and already knowledge that what was purchased was not what the board approved. So in a nutshell, this letter does explain what was purchased. It's different, but it's not a huge difference. It's still within the engineering parameters. They had a grant for $20,730. That's what was approved by the board. Only $19,619 and change was spent. So they need to cut us a check, a refund to the board of $1,100. And I just want the board aware. I think from looking at it, and I'm happy to send the grant committee members or the full board more details of the receipts if you would like to see them. Again, it's not what you approved, but it's within engineering and things that I would believe you would have approved. It just wasn't done the right way. and they acknowledge that. The receipts were very behind, which is why we couldn't release the next round. The refund has yet to get here, to my knowledge, and so that's problematic from a perspective that we're in the next fiscal year and all those kind of things. So I just want to inform the full board kind of that took place, and that's the reason the next round wasn't. And then obviously they would get the same letter, unless you tell me otherwise, that everybody else would for this upcoming grant period. So that's all that I have, I think.
So do we need to make any kind of motion, or does it come from the grant committee to?
I think unless the board has a reason to be concerned. So at the time I didn't have receipts, the concern would have been that the grant money was due back to the board, that the full $20,000 needed to be cut. At this point, I do have receipts that support it. I don't have the refund. No, it isn't what was approved, but it's in line within what the profession was looking at. So if this board does make a motion, you definitely can, whether it's they refund us the full amount, that's in your purview, or whatever else you see fit. Right now, I do need you to know that that's how this played out.
Roxanne, I
Yes.
would like to see their documentation. And I'd like for Alton and the other grant committee members to take a look at it, just to kind of cover bases that we have seen it. And I think we need to send them a letter of caution that, you know, this is a privilege to receive these funds, and that the guidelines are set up, you know, to protect them as well as the citizens of the state of Tennessee who are registrants and end up funding this, and that they must follow the guidelines or suffer consequences. So,
Thank you. I'm taking note. That makes perfect sense.
Go ahead, Kathy, and then I'll go to all.
I was going to ask the same thing. I didn't actually see the documentation, so if we actually saw the actual receipts of the expenditures, that would be nice. But I was just going to say in their favor that I honestly think that what they ended up buying, the GeoJack system, and just so you all know what, I don't know if everybody knows what that is or not, but we use that in our business, and that is actually, you know, a good thing for a geotechnical soils lab to have. Which I think is actually more appropriate than a plant growth chamber, which seems much more along the lines of agricultural as opposed to geotechnical or something like that. So I was just going to weigh in on that. I mean, I don't think it's a bad whatever they were going to buy, but I certainly the GeoJack, and it's not cheap. You know, that's appropriate from my perspective. That's all.
I want to reiterate what Susan said, and I would like to see the documentation too. But also, Roxana, when you send the letters out in May, we may want to emphasize again that it's very important that we receive the appropriate documentation back in a timely manner, and what the ramifications are if we don't. Thank you for doing that.
Blair.
I'll just second that. I think it's important that we set precedent here at this moment where we've now have one university that didn't play by the rules, if you will. And even though it may be a better situation, the truth is we all need to be responsible. So we don't want this to start up and for everybody to start asking for forgiveness. So.
So I think that's the guidance, is to send a letter and get the documentation out to the committee members. Okay, thank you. Did I skip over the NCARB in the annual meeting for your report?
No, I think we talked about who would be funded, who wouldn't, and kind of the status of where we are on those two big annual meetings.
For NCARB we did?
We did, because they actually, theirs is in June, so they've been ready.
I missed
Thank
that
you.
one. Okay, thank you. Again, we talked about definitions committee, and I went ahead and move that for the kind of the engineering committee item that we didn't get to yesterday. Now we have general discussion, and Ashley, I think you've got one of our favorite topics, open records and all that good stuff. So if you don't mind, tell us how bad we are.
Okay, so like I said earlier, I've been asked to present information regarding the Open Records Act and the public meetings. So What is included in open records? Public records or state records include all documents, papers, letters, maps, books, photographs, microfilms, electronic data processing files, and output films, sound recordings, or other material, regardless of the physical form or characteristics made or received pursuant to law or ordinance or in connection with the transaction of official business by any government agency. Meetings and notice are 90% of the Public Meetings Act. Under the Act, notice, agenda, public presence, and minutes are required for public meetings. If the board violates the acts, decisions could be nullified. Tennessee Code Annotated, Section 844-101 provides, the General Assembly hereby declares it to be the policy of this state that that the formation of public policy and decisions is public business and shall not be conducted in secret. This part shall not be construed to limit any of the rights and privileges contained in Article 1, Section 19 of the Constitution of Tennessee. The Public Meetings Act is remedial in nature. Tennessee Code Annotated Section 844-102A provides all meetings of any governing body are declared to be public meetings open to the public at all times, except as provided by the Constitution of Tennessee. The Public Meetings Act applies to all boards and commissions. The Public Meeting Act applies to every meeting of a board or commission. Per Tennessee Code Annotated, Section 84102, B2, meeting means the convening of a governing body of a public body for which a quorum is required in order to make a decision or to deliberate toward a decision on any matter. Committee and subcommittee meetings are included. What's not a meeting? Meeting does not include any on-site inspection of any project or program. A meeting also does not include a chance meeting of two or more members of a public body. However, no such chance meetings or informal assemblages can be used to decide or deliberate public business in circumvention of the spirit or requirements of the Act. Two or more members of a public body may share a meal together in which public business is conducted, but such discussion should not constitute deliberations. Lunch breaks, restroom breaks, smoke breaks, recesses between morning and afternoon sessions, adjournments between 2 days of a multi-day meeting, those would not be considered meetings. But at all of those times, board business should not be discussed. Tennessee Code Annotated, Section 844-103, provides that regular meetings and special meetings count as meetings, and all are subject to the Public Meetings Act. The only exception is executive sessions. Executive sessions occur when one or more members meet with the board's attorney, and the board is under lawsuit or has been threatened with suit, and the members ask their attorney questions related to such suit. The board may not deliberate about any specific matter before it or potentially before it in an executive session. Now we're going to talk about electronic communications. You can email the chair a news article or indicate you would like something included on the agenda, but you cannot say, here's a news item about one of our licensees, we should consider revocation. If a commissioner has a question about the legal report, you are allowed to ask the board attorney or disciplinary counsel, but you should not say that you have taken an action as a commissioner and now someone is upset or those types of things. If you send an email or pick up the phone to call another commissioner, that is not a chance meeting. Even if you don't discuss board business, it gives a strong appearance of impropriety, and for safety's sake, it ought to be avoided. We are allowed to have individuals call in by phone, but all votes must be roll call votes. If more than one member cannot attend in person, the meeting may proceed as normal if the members physically present make a quorum. If the in-person members do not make a quorum, the board must adopt and promulgate a statement of necessity before the meeting can go forward. The Public Meetings Act is construed most favorably to the public and is all-encompassing and applies to every meeting of a governing body, except where the statute on its face excludes its application. The public has a right to attend and observe your meetings, but not the right to participate. You are not required to let just anyone speak. There is a three-pronged test that must be met for there to be adequate public notice. 1, the notice must reasonably describe the purpose of the meeting or the proposed action to be taken. 2, the notice must be posted at a time sufficiently in advance of the meeting in order to give the public both an opportunity to become aware of and to attend the meeting. And 3, the notice must be posted in a location where a member of the community could become aware of such notice. This can be internet, newspaper, and bill posting. Our usual practice is to put public notice on the board's website and the department website. The adequacy of public notice depends on all the facts and circumstances, and no single factor is dispositive. In other words, all prongs are important. There are penalties associated with a violation of the Act. The legal effect would be nullity. The practical impact is substantial costs assessed against annual operating budgets. So in a nutshell, and in sum, the Act is designed to make sure that board business is conducted in a way accessible to the public. The Act applies to you both as an individual member and collectively as a board. All gatherings of more than one member are meetings and are covered by the Act, including regular, special, and emergency meetings, and including committee and subcommittee meetings. For every meeting, you must give adequate public notice in content, location, and time. If you violate the law, any violative acts are void, and costs of litigation may be assessed against the board. If you are unsure as to whether something is included in the Act, you can always contact me individually and I will help you.
I have a question. This is for you individually. You said, what's the difference between a discussion and deliberation? We can have discussion, we can't have deliberation. What's the difference, just for me?
Well, you can't discuss, deliberate, debate, or decide about board business.
There was a statement you read that said we can have discussion but not deliberation.
You could have a discussion about how nice the weather is today, but you could not deliberate on anything that would be potentially board business or could be considered as board
We couldn't
business.
deliberate whether it may get worse later on, the weather. I'm joking. I do have a question. Are you statutorily required to read us that, or have we done something wrong?
Every board was provided with the presentation.
I think a few years ago we actually had a video and somebody else came and presented to the full boards. I don't know if you all did. We just don't have that person anymore. So,
but I did hear that right, that we can have discussed, but I'm still not sure because in your presentation, it didn't say discussions about the weather. It said discussions, open-ended.
I meant when I said you can have discussions, I meant you could have like casual discussions about things not related to board business in any way. I used weather as an example of something that you could have a discussion about, but you couldn't have any type of discussion or deliberation about anything related to board business at all outside of a public meeting.
I'm going to go back to that just a little bit, and I know that's a shocker. But we know that there's not something that's on the board's agenda. Okay? We know that it's not something that we have coming in front of us. And I go to Blair and I say, landscape architects, what's their level of effectiveness on grading plans? Again, it's not in front of us. It's not board business. It may come in front of us at board business at some time in a definition section. I don't know. But I'm asking for, to me, that's discussion I'm asking him because I know who he is. I know what his profession is. Is that discussion or deliberation because it may potentially come in front of the board? I would think so.
I have not specifically researched into your specific hypothetical question, so I cannot provide you with an answer. However, with an answer on that specific issue, I can tell you that, like I said, you are not allowed to communicate outside of public meetings if the communication is in any way related to board business or could be viewed as being related to board business.
It wouldn't be board business?
Yeah, that's correct. It's not.
Okay. I just want to make sure.
Ashley, obviously you were reading something that sounded like it must be some kind of PowerPoint presentation so if that's true, can you tell us exactly what the title and the date and the source of the thing is that you just read? And then can you provide it to us as an email? Because obviously it's something you're referencing and you want to go on somehow I get the feeling that there's an intent to go on the record as having told us these things. So I'd at least like to see it for my own self.
You are correct. It is a presentation. However, it has not gone through all of the publication requirements yet, so I cannot provide it to you. But once it has gone through that process with the department, I can provide it to you. I just can't provide it.
So it doesn't
today.
have the seal of approval of the department yet?
It hasn't gone through our publications process yet.
Well, they really shut you down on what you can say. So, well, if it hasn't gone through the review and approval process and it's not an official document, it's not an official document that you can share because it can't be made public?
Correct at this point, yes.
So it really has no bearing on us whatsoever. Yeah. Seems counter to the whole point of it. I don't understand. Well, then if you're going to do that, then I would just say that whatever it is that you want us to know and that you want to hold us accountable to, I think needs to be written and distributed and not just spoken into the record. Then later on we all get tripped up because we didn't get a chance to actually see it. So it seems kind of...
Frank, did you have a question?
If I was going to make an attempt at making a distinction between the two, I think you would be the difference between discussing a topic, as an example, does NCARB have a definition for architecture, as opposed to deliberating whether somebody should be fined for something or how much the amount should be. In other words, one is talking about how to come up with getting together outside the board on how some result should be in the board. The other is just talking about general discussion of general topics not related to how the board acts. That's my attempt.
Well, no, I think I would 100% agree with you. But what I don't want to see is discussions between practitioners about items that may never appear in front of this board and are general in nature for the areas that they represent. Seem to me to be discussion items that should be wide open for anybody, any one of us to talk about with any other member of this board, because we are not making a decision based on that discussion. I'm just simply, I've got this issue that I'm dealing with in my business. How are you dealing with that? I mean, and that to me is a discussion. That to me is not deliberation. And I just want to make sure that we do have some line there that we understand there is a difference between that and a deliberation, because I don't want somebody to say, oh, I've checked your emails and you sent an email to Frank asking him how he dealt with this type of client. Okay. Now that may come up as board business later on because we're talking about how QBS, right? So, I mean, it may be, but I just don't want those normal that we do every day to different people in our profession type conversations to be construed as deliberative and violation of sunshine law. Because I don't, we do business with each other on different levels, and it seems to me that if I'm asking Alton how they came up with a certain pump curve, that's a legitimate question, and I know that he's got the answer to it. I'm going to reach out to him before I do somebody else. And I understand, I got it, but I think we don't need to be so focused on we can't ever talk to each other unless we run into each other at Sam's, and I don't think that was ever the intent. The intent was to deliberate and make decisions about stuff, although there's a part of me that disagrees with some of that. I think sometimes getting to see something with somebody else's opinion while you've got time to think about it before you deliberate has got some real value to making the best decision for the public. But anyway, okay, I just wanted to ask the question because it's not defined in my mind.
And if I could add several of you might have been here in the last presentation. I want to say 2014 or 2015. The vast majority of the presentation actually was folks asking questions. I mean, the questions were exactly like you did. When we're having dinner, can we talk about this? And, just a lot as a license, but we're in the same industry, can we call? So you're not alone in asking those. They're very legitimate. And I don't think anyone was handed any document. They were brought in to train and kind of hear some even bad examples of what could go wrong when you didn't realize you were talking about board business, but it became board business 6 months later, and then some of your decisions and the meeting were questioned because of that. So it's a chance, I think, for legal to kind of give us a heads up of needing to try to do everything that is about business to the best that you can, always in that open meeting. So if she's able to get that approved, we can send it out. But those meetings that were even with a big PowerPoint in front and people watching someone, they involved a lot of questions, just like you all did, because you're friends and you see each other. So it's not intended. I agree with you, Robert, for you to not talk about someone's wedding, your kids, or question. Thank you.
Anything else?
Are we going to bring up the NCARB? We had our NCARB regional meeting since the last one, and it was, as you guys know, it was started in Nashville, so they had a big event, and Rick and Frank and Roxana, all of us were there, and Rick actually read a proclamation by the governor, and it was well received, and we all had it was a good time. We were a good host as well. So.
I've got one thing, and that has come up to me more than once since I've been on the board, and it involves the reference manual for board officials that we have. It's accessible on our website, and what my concern is, it has to do with definitions of types of occupancy. And what my concern is, it references the 1985 Standard Building Code, which is long gone, obviously. And it does give definitions for types of occupancy. Some of it no longer is relevant. Some of it never was relevant. And it just needs to be updated. And if, you know, and I'm pretty sure the version that's on our website is the most recent, and it's probably in 2018 or whatever. But I think that needs to be looked at. It's and the reason it's come to me is a couple of times I've been reviewing cases, and people say, well, we're going by the 1985 Standard Building Code. And it doesn't say that if you read it closely, but if you just read it and you want to try to say something, then that's what you grab a hold of.
Go ahead.
Unfortunately, I'm the chairman of the Publications Committee, I think, unless Robert's changed it. And this has come up before. And the reason it's like that because that edition of the code is in our law.
I understand that.
So the law would have to. The law probably would have to be changed. I guess Ashley could weigh in on that, but that's what I was told when that question came up in a committee meeting, gosh, years ago.
And that's the reason I hesitate to bring it up, because changing laws is not a simple thing. And when you open it up, you're opening yourself up for all kinds of amendments and et cetera. But I think it needs to be addressed. I think we've reached the time where that needs to be addressed.
Well, I think, again, it's going to require a statute. I mean, it's going to require a law change because at the time we brought it up and we went through that process to look at doing that, we couldn't get it on the administration's list to be looked at. And the decision was, since it's strictly used as a definition and not a reference to the code that you're supposed to use, it just says definition as, and I'm not doubting that what you're saying about not applicable is right, but that was the reason we need to. So, I mean, if it's something that we need to get changed somehow, we probably need to, that's probably going to have to be something that probably the professional societies, professional societies are going to have to weigh in to get changed, because I don't think it's going to be able to be generated from this board by the time. How will it make the cut to get in the packet? And that's what historically has happened. It's not risen to the level of some other things that we're trying to get statutory changes to. So we would have to ask the professional societies to help us navigate that law change.
And I think the definitions are 95% relevant. It's just, if you just took out that it's referenced the 1985 Standard Building Code and just say, here is the definition, whether it's from then or today.
Or even refer to the most current code.
Or that would be good.
Yeah.
That would be good. You know, and carry it further, the most current code adopted by the Tennessee State Fire Marshal's Office.
Yeah, exactly.
Yeah, definitely make sure it's the Fire Marshal's Office, because you have such a breadth between different communities and what they use.
We work with 10 different versions of
that.
that.
Who knows?
Yeah.
I think that's good. So Ashley Catch has got something to do, it sounds like. Okay. But again, I think we've tried that in the past, and it just would not make its way into the pecking order of what we as a board could send up through the process.
Right, but it is a reference that our board has on their website for our
understand. Sounds like it's a pretty easy strike through or something like that. You know, replacing 4 or 5 words probably takes care of the whole issue. So. All right. Well, I'm disappointed in my performance today. It's now 12:30. I had hoped to get us out here in a little quicker time frame. So here in another couple months, you'll have a new chairman anyway, so it won't make any difference, right? All right.
That does raise a question. I think, and Roxana, you might tell me, I think you and I are going off the board unless we're reinstated. Are there any others?
So unless you've gotten a letter thanking you for your service, you would continue to come to the meetings. But I don't think that those letters have all been done or reappointments. But we have provided the list from every one of our programs regarding vacancies, expiration dates, and all that. So I know that the governor's aware, and we'll probably get to all the different programs.
We will also, Kathy, remind we probably need to have nominations committee meeting coming up, and I don't know if that's we definitely have to do it in the next meeting because the next meeting will be June. And July 1st is supposed to be our new slate, so we're probably a meeting behind with that recommendation. Here comes from the vice chair.
On, get ready.
I think then architect would be vice chair, engineer would be secretary. I think that's. We probably do need to have that committee meeting next committee, and have to, yeah, definitely. So I don't know. Is Rick Thompson still over the nominations committee? I think I got to call him right now.
Me too.
You think so? You gonna do that?
It's against the sunshine law.
No, we can have him on the speakerphone. We can have Rick Thompson on the speakerphone. I just want to hear the background.
the slot machines.
Okay, but we do need to probably do that in the interim so that we can present a slate of officers at the June meeting for the upcoming year, because we run out at the end of June, right? July 1st is our rollover. Very good. Anything else?
I have one more item. I believe this or not, I read through this document. There's a lot of good information in here. Really is. So it was very helpful. And my last comment is, I'm reviewing this information engineer intern certification sheet. Do you all still use T-squares? I'm sorry. I'm sorry. That's it.
Compasses
and T-squares.
Why not? Why not? You got a problem with that?
No, very efficient.
You still draw a straight line with it. That's more than some people with computer programs do. All right. Good deal. Well, I will ask for adjournment.
I'll move.
You have a second? Doesn't matter. We're going to adjourn anyway. Everybody have a safe trip home or wherever you're heading after this meeting, and we will see you all in June. Thank you.
Bye, everybody.
Bye, Susan.
Bye,
Get well.
Susan.
Yeah, we're staying at the Moss Flower. It's a nice